afternoon, friends. Welcome to the world of business law. I, Professor Kunal Shah, is over here to present you the marathon revision of business law. Friends, in our yesterday's lecture, we started with a topic called as Indian Contract Act 1872, wherein, friends, if you all try to recollect, we have divided this entire chapter into five parts. Number one, what is contract? Number two, types of contract. Number three, how to form a contract. Number four, how to perform a contract. And number five, how to discharge a contract. Out of these five topics, we have successfully completed what is contract and types of contract. And yes, we had also begun our journey towards how to form a contract. In practical life, whenever we are going to form a contract, we would like to form a valid contract. For that reason, we need to fulfill the provisions of section number 10 of Indian Contract Act 1872, wherein we have completed a topic towards proper offer, proper acceptance, intention to create legal relations, competency of a party to enter into a contract, and we also completed consideration. Now, friends, let us move on ahead. Let us move on ahead and let us discuss the balance portion towards Indian Contract Act 1872. Yes, friends, over here we have got a rule which states stranger to a contract cannot sue. Yes, the rule says stranger to a contract cannot sue. The reason behind this is nothing but lack of closeness between the parties. That is, lack of privity between the parties. So, whenever I talk about a stranger, then sorry to say, stranger to a contract cannot sue. There is the lack of privity between the parties. For example, there is a contract between Mr. X and Mr. Y. Then, in that case, if at all there is a breach of contract, then Mr. X can file a case against Mr. Y. In a similar way, Mr. Y can also file a case against Mr. X. But can Mrs. X can Mrs. X file a case against Mr. Y? No. Mrs. X cannot file a case against Mr. Y stating that Mr. Y have done a breach of contract. Not possible. First of all, there was no contract between Mrs. X and Mr. Y. See, Mr. X and Mrs. X are close to each other, but there is no contractual relationship. There is no contractual relationship between Mrs. X and Mr. Y. So, because of the lack of privity between the parties, sorry to say, Mrs. X, you cannot file a case against Mr. Y. It happened in a case law of Dunlop Tires versus Selfridge Corporation. First of all, there was a contract between Dunlop Tires and Dew and Company. Later on, there was a contract between Dew and Company and Selfridge Corporation. So there was no direct contract between Dunlop Tires and Selfridge Corporation. One fine day, Selfridge Corporation did a breach of contract with Dew and Company, for which Dunlop Tires filed a case against Selfridge Corporation. The honorable judge over there gave a decision that, sorry to say, Dunlop Tires, you cannot file a case upon Selfridge Corporation because of lack of contractual relationship between you both. So, whenever I talk about a stranger, then sorry to say, stranger to a contract cannot sue. Sorry to say, stranger to a contract cannot sue. But wait. Yesterday, we done a case law of Chinnaya versus Ramaya, wherein in that case law, I had given you an explanation stating that stranger to a consideration can sue. Yes, there can be a stranger for consideration, but there cannot be a stranger to a contract who can sue. Now, friends, whenever we are going to discuss without something called as rules, then yes, rules have got exceptional cases. Rules have got exceptional cases. When I say rule, follow the rule. When I say rule, then follow the rule. But when I say exceptional cases, then in that case, overrule the rule. In exceptional cases, overrule the rule. The rule says stranger to a contract cannot sue. But yes, in exceptional cases, stranger to a contract can sue. Generally, stranger to a contract cannot sue. But yes, in exceptional cases, stranger to a contract can sue. Okay, if you all go back to a date called as 8th November 2016. Yes. Exactly 4 years. Exactly 4 years. On 8th November 2016, the central government of our country came out with a rule called as demonetization. The moment the rule of demonetization was being announced, within next few minutes they announced certain exceptional cases. The rule said 500 rupee note and 1000 rupee note shall be considered as invalid. But after few minutes, the government announced that this rupee are still valid if you are exchanging it at a bank, or you are exchanging it at an hospital, or at a medical shop, or at a petrol pump, etc. So whenever there is a rule, then yes, rules comes with exceptional cases. When I say rule, follow the rule, but in exceptional cases, overrule the rule. Friends, we have got a rule stating stranger to a contract cannot sue. We have got a rule stating stranger to a contract cannot sue. But yes, there are certain exceptional cases wherein stranger to a contract can sue. Yes, in case of trust and beneficiaries, in case of family settlement, in case of partition of HUF, assignment, acknowledgement of debts, covenants with land, and contracts by agents. In this seven exceptional cases, in this seven exceptional cases, stranger to a contract can sue. For example, there is a case of trust and beneficiaries. I and Karthik entered into a contract. I and Karthik entered into a contract wherein I made a promise to Karthik that, hey Karthik, I will be paying you a sum of rupees 10,000 per month, and this money should be specifically been used. This money should be specifically been used for an orphan child named Susmita. So over here, the contract is entered between me and Karthik, wherein the entire benefits of this contract is going to get transferred to an orphan child called as Shushmita. Now, one fine day, if I don't pay 10,000 rupees to Karthik, then in that case also, Shushmita still has a right to file a case against me. Though she was not a party to a contract, she was a stranger. Generally, stranger to a contract cannot sue, but over here, Shushmita was acting as a beneficiary. And in case of beneficiaries, law says stranger to a contract can sue. Generally, stranger to a contract cannot sue. Generally, stranger to a contract cannot sue. But in exceptional cases, stranger to a contract can sue. And the very first exceptional case over here was in case of trust and beneficiaries. Let us move on ahead to the next exceptional case, which talks about a family settlement. Yes, whenever the assets of the family are being distributed, then the person who is not a contracting party over here, the person who is not a contracting party over here, still has the right to enforce this contract to the court of law. So yes, even in case of family settlements, stranger to a contract can sue. Yes, even in case of partition of an HUF. When I talk about HUF, it is nothing but a form of doing a business, that is Hindu undivided family. Whenever there's a partition of this HUF, then in that case also, any person who is acting as a stranger to a contract, still that person has a right to enforce the contract to the court of law. Generally, stranger to a contract cannot sue. But when it is a case of trust and beneficiaries, when it is a case of family settlement, when it is a case of partition of HUF, then yes, in all these cases, stranger to a contract can sue. The next exceptional case over here is about assignment. Assignment stands for transfer. Over here, if I'm transferring my right to a person, that means that person has got all the rights which I was utilizing previously. For example, I am having a right. For example, I am having a right to recover 10 crore rupees from JK Shah sir. JK Shah sir has made a promise to me that he is going to pay me 10 crore rupees. He is going to make me the payment of 10 crore rupees. Now, over here, can I say JK Shah sir is the promiser? Yes, and I am acting as a promisee. JK Shah sir is the promiser, and I am acting as a promisee. Now, it is the obligation of JK Shah sir to pay me 10 crores. Then it means it is my right to recover 10 crore rupees from JK Shah sir. Now, I just had a plan to transfer my right to a person called as Aryan. I just made a call to Aryan. And I told to Aryan that, hey Aryan, I'm having a right to recover 10 crore rupees from JK Shah sir. I am transferring this right to you, Aryan. Aryan said, okay, sir, you can transfer this right to me. Which means now it is Aryan who is having a right to recover 10 crore rupees from JK Shah, sir. So over here, I have transferred my right to Aryan, and that is nothing but a case of assignment, that is to transfer the rights. Now, Aryan has got a right to recover 10 crores rupees from JK Shah sir. If now JK Shah sir refuses to pay 10 crores, then yes, Aryan has a right to file a case directly against JK Shah sir. JK Shah sir now cannot say that, Aryan, I was having a contract with Kunal Shah, you are a stranger. Sorry to say, stranger to a contract cannot sue. Then Aryan will say that, sir, accepted that you are having a contract with Kunal Shah. But Kunal Shah has transferred his rights to me, that is Aryan. Now, if at all Kunal Shah was not going to receive 10 crores, then Kunal Shah was also having a right to file a case against JK Shah sir. But this right, Kunal Shah sir has transferred to Aryan, which means Aryan, though being a stranger to a contract, he can still take the contract to the court of law. So generally, stranger to a contract cannot sue. I'm sorry. Generally, stranger to a contract cannot sue. But, but there are certain exceptional cases wherein stranger to a contract can sue. The next exceptional case over here is about acknowledgement of debts. Over here, whenever a person is given an acknowledgement that he is a person who has got the money on behalf of another person, then yes, it is the duty of that person to repay the money back to the original person. For example, A is a person having a liability to pay to Mr. C. So A is having an obligation and C is having a right. But over here, A handed over the money to Mr. B. Over here, B gave a call to Mr. C that, hey, C, I have received your money. On your behalf, I have received the money from Kunal Shah. That money I will pay you in a short time. She said, okay. If at all B fails to pay the money to C, then yes, there can be a case over here. Over here, a person cannot say that stranger to a contract cannot sue. Over here, it's being an exceptional case where a stranger to a contract can sue. The next over here is about covenants with land, that is agreement with land. For example, there was a zamindar named as Chunnilal. The name of the zamindar is Chunnilal. Now Chunnilal gave his property on lease. Chunnilal gave his property on lease to a person called as Mr. Mark. So Mark is the ultimate user of the property, and Chunnilal is nothing but the owner of the property. Mark said that I am going to utilize your property for social activities. I'm going to construct schools, I'm going to construct hospitals, I'm going to construct various colleges, and all of these things will be given as the basic necessities to the underprivileged people of the country. Chunilal said, okay, okay, you can use my property for social activities. So Chunilal has given his property on lease to Mr. Mark, and Mark is going to use that property for social activities. Over here, the contract got entered between Chunilal and Mr. Mark. The moment the contract got entered, after 15 days of signing the contract, Mr. Chunilal died. The moment Chunilal died, can I say all his property will now get transferred into the name of the legal representative of Chunilal? So the property is now under the hands of Chunilal Jr. That is nothing but the legal representative of Mr. Chunilal. Now, Mr. Mark, who had made a promise that he is going to use this property for social activities, is now using that property for commercial activities. Can I say Mr. Mark has done a breach of contract? Yes, Mr. Mark has done a breach of contract. For that case, still Chunnilal Jr. has a right to file a case against Mr. Mark. Mr. Mark cannot say that I was having an agreement with your father. Your father died, hence the contract died. No, 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 no. The entire property got transferred to Chunnilal Jr. Though Chunnilal Jr. is a stranger, generally, stranger to a contract cannot sue, but in exceptional cases, yes, a stranger to a contract can sue. The last exceptional case over here is about contracts by agents. Whenever there is a contract been entered by agent, see, agent is a person who works on behalf of a principal. Any person working on behalf of a principal is called as an agent. So over here, any contracts entered by the agents, then in that contract, the contract is between the agent and the client. The principal is an outsider, the principal is a stranger over here. But still, that principal is having a right to take the contract to the court of law. Though the principal is a stranger over here, generally, stranger to a contract cannot sue. But over here, stranger to a contract can sue because it falls under an exceptional cases. So friends, just make a rule. Stranger to a contract cannot sue. But in exceptional cases, stranger to a contract can sue. Let us go on further to the next rule, which talks about no consideration, no contract. The next rule, which talks about no consideration, no contract. Pretty obvious, na? Pretty obvious. See, whenever I talk about a contract, whenever I talk about a contract, so can I say contract is nothing but 2b plus 2e plus 2h. So whenever I talk about a contract, contract is nothing but 2b plus 2e plus 2h, wherein 2b represents promise, 2e represents agreement, and 2h represents a contract. For a promise, there has to be an offer and acceptance of offer. For an agreement, there has to be a promise along with a consideration. For a contract, there has to be an agreement which has to be enforceable by law. Now if at all, I say that there is no consideration, then pretty obvious there won't be an agreement, and if there is no agreement, how can there be a contract? So, friends, for that reason, we have got a rule which says no consideration, no contract. No consideration, no contract. But friends, as rightly said, whenever you have a rule, then yes, rules have got certain exceptional cases. Over here, the exceptional cases says that no consideration, still there is a contract. No consideration, still there is a contract. Rule, no consideration, no contract. No consideration, no contract. But in exceptional cases, no consideration, still there is a contract. There are few exceptional cases. Number one, in case of love and affection. Number two, in case of a compensation paid for past voluntary services. Number three, promise to pay time bar debts. In case of gift, gratuitous bailment, charity, and in case of contract of agency. So, yes, friends, in this seven exceptional cases, yes, friends, in this seven exceptional cases, no consideration, still there is a contract. The very first exceptional case talks about in case of love and affection. See, whenever there is a contract getting formed out of love and affection, first of all, there is no contract. But wait, if it is in a return form, it has been registered, and yes, there is nearness in relation, then yes, it can be a contract. And in all that cases, no consideration, still there is a contract. Let me give you a simple example. One fine day, my father was touched. My father said, "Wow, Kunal Shah, you are doing a wonderful job. Wow, that's simply fabulous." My father said out of love and affection that, "Hey Kunal Shah, the property which is situated at Ahmedabad now onwards belongs to you." So my father gave a written agreement wherein my father wrote that I, father of Kunal Shah, is transferring the entire titles of Ahmedabad property to my son Kunal Shah. Signed by my father, signed by me. This document was registered. Now, when my father gave a promise to transfer the property of Ahmedabad to my name, then in that case, did I give something in return to my father? No. Generally, no consideration, no contract. But over here, it is still a contract because it falls under an exceptional case. See, there was a nearness in relation between me and my father. Yes, it was in a written form, and yes, it was also registered. Then in that case, no consideration, still there is a valid contract. Now, who is the legal owner of the property of Ahmedabad? Yes, the legal owner of the property of Ahmedabad is Mr. Kunal Shah. My father is giving a promise to hand over the entire property of Ahmedabad to my name. But in return, I was not giving him anything in return. There was no consideration. But over here, still there is a contract. Can I say the same example can also be taken in case of gifts? Whenever we are accepting a gift, then we don't have an intention to give something in return to another person. So even in case of gifts, no consideration, still there is a valid contract. The second exceptional case over here is about compensation paid for past voluntary services. So if at all in practical life you have given a voluntary services, those services were given by you in past. Now, the person to whom you gave that services, the person to whom you gave that services, that person had given a promise to compensate you. That person had given a promise to compensate you. Now, for that person to give a promise to compensate you, the person was not getting something in return. No consideration, no contract. But in this case, no consideration, still there is a contract. Let me give you an example. One fine day, I was just sitting by a roadside and I just heard a voice coming from a faraway place stating, thief, 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 thief. The group of persons were approaching towards me. I caught the thief and I took over the purse from him. He was holding a purse which was actually owned by an old lady. So I was over here giving a voluntary services of catching a thief. No one had told me to catch hold of the thief. The moment I handed I'm sorry, I'm sorry. The moment extremely sorry. The moment I handed over the purse back to the old lady was very much happy. She said to me that Kunal sir, I would like to compensate you for this activity. So she promised me to pay a compensation of rupees 10,000. For her promise, is she getting something in return? Sir, she received her purse now. Arey, that purse already belonged to her, yaar. So she is not getting something in return. Then also, if she is making a promise to compensate me for my past voluntary services, then in that case, even if there is no consideration, still there is a valid contract. Yes, there is a valid contract between me and that old lady. Friends, each and every example of mine which I am giving right now has to be assumed it is in a return form. It is in a return form. Then only they are enforceable, na? If they are by words spoken, then sorry to say they are unenforceable in nature because of some technical defects. So the rule says no consideration, no contract. But yes, there are certain exceptional cases wherein even if there is no consideration, still there is a valid contract. The very first exceptional case was about love and affection. The second exceptional case was about compensation paid for voluntary services. And one more exceptional case, which we have already covered, was nothing but gift. The next exceptional case, promise to pay time barred debts. Promise to pay time barred debts. Yes, whenever there is a promise to pay a time barred debt, then in that case, even if there is no consideration, still there is a valid contract. First of all, what do you mean by time barred debts? Time barred debts are debts which are declared as dead by law. They are the debts which are declared as dead by law. Sir, when will a law declare a debt to be dead? When will law declare a debt to be dead? When the aggrieved party does not take a course of action within 3 years. See, in India, we have got an act called as Limitations Act 1963. As per the provisions of Limitations Act 1963, whenever you are an aggrieved party, you should have taken a course of action within a stipulated period of time. In case of financial transaction, the stipulated period of time is 3 years. One fine day, I have taken a loan from Mr. Karthik, which means I am a debtor and Karthik is the creditor. The loan was taken in the year of 2010, and I made a promise to Karthik that I shall repay back the loan in a year called as 2020. So the date of performance is 2020. In the year of 2020, I did not repay the loan back to Mr. Karthik, which means I have done a breach of contract, which means Karthik is an aggrieved party. Karthik can file a case against me maximum within 3 years, that is on or before 2023. If Karthik fails to file a case on or before 2023, then later on, Karthik cannot file a case against me. Because in the eyes of law, the debt is declared as dead by law. Now, it is the debtor who has got a right to revive a time barred debt. Practically, debtor won't do it. But if at all the debtor does, then the promise made by a debtor to revive a time barred debt, in that case, there is no consideration, but still there is a valid contract. Now, for example, in the year of 2024, I personally went to Karthik and I said to him that, hey Karthik, I am making a promise to pay back you the loan which I had taken previously and which was declared as debt by law. I'm making a promise to repay you that debts. So I'm trying to revive a time barred debt, which means as per the new agreement, I am going to pay something to Karthik, but I'm not going to receive something from Karthik. But sir, you already received a loan now. But that loan is already declared as debt by law. It's a time barred debt. So whenever there is a promise made by a debtor to pay a time barred debt, then in that promise, no consideration, but still there is a contract. Generally, no consideration, no contract. But in exceptional cases, no consideration, still there is a valid contract. The next exceptional case over here is about gratuitous bailment. See, gratuitous is a word derived from gratitude. Gratitude stands for thankfulness, that is no consideration. The person does not have an expectation of something in return. What is bailment? Bailment stands for transfer of possession of goods. Bailment stands for transfer of possession of goods. The person is just transferring the possession of goods. One fine day, I wanted to travel from a place called S, A, to a place called as B. So I just thought to travel through a bike. I did not have a bike. So I went to my friend and I asked him to give me a bike. So my friend handed over me the keys of the bike. That does not mean that my friend has sold the bike to me. No, he has just transferred me the possession of the bike, which means there is a contract of bailment between me and my friend. This contract was entered purely out of thankfulness. My friend did not expect something in return from me. Then in that case, no consideration, still there is a valid contract. Yes, friends, in your inter CA, there is an individual topic called as contract of bailment, wherein I am going to give you in-depth knowledge towards the contract of bailment itself. Over here, when my friend has handed over me the keys of the bike, then once my purpose is accomplished, I need to give back the keys back to my friend. I was not the owner of the bike, I was just having the possession of the bike. Generally, no consideration, no contract. But yes, if it is a case of a gratuitous bailment, then in that case, no consideration, still there is a valid contract. The next exceptional case is about charity, that is donations. Even in case of donations, we don't expect something in return, but still there is a valid contract. Yes, in case of donations, there is no consideration, but still there is a valid contract. Last, in case of contract of agency, law says in order to form a contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. So for formation of contract of agency, there may or may not be a consideration. First of all, who is an agent? Who is an agent? Agent is a person working on behalf of another person. So any person working on behalf of another person is called as an agent. I repeat, any person working on behalf of another person is called as an agent. Now, law says in order to form a contract of agency, there may or may not be a consideration. If there is a consideration, still it's a contract of agency. If there is no consideration, still it is a contract of agency. One fine day, I told Karthik that, hey Karthik, would you like to go on my behalf to a place called as Delhi and work on my behalf? Karthik said yes, which means there is a contract of agency between me and Karthik. I never spoke about consideration over here, but still there was a contract of agency between me and Karthik. So, in order to form a contract of agency, there may or may not be a consideration. Even if there is a consideration, it's a contract of agency. Even if there is no consideration, it still remains a contract of agency. So, friends, these were the two rules which we had to discuss. Rule number one, stranger to a contract cannot sue. And rule number two, no consideration, no contract. Let us go on to the next topic, which talks about free consent. Free consent. Yes, friends. Whenever in practical life we want to form a valid contract, then one of the essentiality under section number 10 talks about free consent. See over here. See over here. Free consent is one of the essentiality towards section number 10. But friends, before making you all understand what is free consent, you need to first understand what do you mean by the word called as consent itself. The word consent is given under section number 13 of Indian Contract Act 1872. Consent stands for consensus ad idem, that is identity of minds for the same thing in the same sense. Meeting of minds for the same thing for the same sense. I wanted to sell my car to Mr. Karthik. I wanted to sell my red Audi car to Mr. Karthik, and Karthik wanted to buy that red Audi car only. So over here, there was a consent between me and Karthik. The word consent has got a plain English meaning called as permission. I'm sorry. The word consent has got a plain English meaning word called as permission. Called as permission. Over here, whenever you want to enter a contract with a person, whenever you want to enter a contract with a person, then yes, you require the permission of that person. You require the permission of that person. Without his permission, you cannot enter into a contract. But that permission should be taken freely. Freely. It should not be taken by force. It should not be taken under moral pressure. It should not be taken by frauds. It should not be taken by misrepresentation. It should not be taken by mistake as well. So in practical life, whenever you want to form a valid contract, in practical life, whenever you want to form a valid contract, then in that case, the consent of the parties should be a free consent. The concept of consent was given under section number 13. However, the concept of free consent is given under section number 14. Section number 14 says that free consent is a consent. That's so wonderful. Section number 14 says free consent is a consent which shall not be taken either out of coercion, undue influence, fraud, misrepresentation, or mistake. If you are taking someone's consent, if you are taking someone's permission out of coercion or out of undue influence or out of fraud or out of misrepresentation or out of mistake, then sorry to say, there is a consent, but there is no free consent. There is a consent, but sorry to say, there is no free consent. Which means there would be a contract, but there won't be a valid contract. In order to have a valid contract, law says the consent must be a free consent, which means the consent should not be taken by coercion or undue influence or fraud or misrepresentation or mistake. So we have to discuss all of them in detail. What is coercion? What is undue influence? What is fraud? What is misrepresentation? And what is mistake? Let us first of all discuss the meaning of the word coercion. The concept of coercion is given under section number 15 of Indian Contract Act 1872. See, basically, coercion means a kind of a force. It is a kind of a force. Whenever you are trying to commit any activity which is forbidden by Indian Penal Code, or you are threatening to commit an activity which is forbidden by Indian Penal Code, or you are unlawfully detaining someone's property, or else you are threatening that person that I'm going to detain your property unlawfully, then in that case you are doing nothing but a coercion. One fine day, I wanted to purchase the property of Mr. Aryan. So I went to Aryan and I told to Aryan that, hey Aryan, I would like to buy your property only for rupees 100. Aryan said, sorry sir, not interested to sell you the property for rupees 100 only. I said, why Aryan? Aryan said, sir, the value of my property runs into crores. You are giving me an offer to buy a property at only 100 rupees? Sorry, I am rejecting your offer. I got touched. I got angry. And now, at a pinpoint of a gun, I said to Mr. Karthik, sorry, at a pinpoint of a gun, I said to Mr. Aryan that, hey Aryan, now, would you like to sell your property to me for rupees 100 only? Aryan said, yes, sir. Please don't fire a bullet upon me. I am ready to sell my house to you for rupees 100 only. See, see, Aryan has given his consent. Aryan has given his permission to sell the property. But this property was not been, the consent was not been given freely, it was given by force. Whenever you are taking someone's consent by force, it is nothing but coercion. Under English law, it is called as duress. It is called as duress. Yes, coercion can come from a stranger. Coercion can also be given for a stranger. I said to Aryan that, hey Aryan, would you like to sell your property to me for rupees 100 only? Aryan said, no sir, not interested. Two simple words get lost. I said, okay Aryan, that's your choice if you don't want to sell the property to me for rupees 100 only. But wait Aryan, right now it is 12:45. One of my close and dear friend will give you a call at 1:30. Kindly pick up the call and have a nice conversation with him. Aryan said, okay, I will have a conversation with your friend. Now sharp at 1:30. My very good friend, Mr. Dawood Ibrahim, gave a call to Mr. Karthik. You just now imagine, huh? When Mr. Dawood Ibrahim gave a call to Mr. Aryan, sorry, not Karthik, Aryan was frightened. Out of fear, Aryan ran to me at 1:45 and he said to me, sir, I received a call from D gang. Sir, please, sir, I'm ready to sell my house to you for rupees 100 only. See, coercion did not come from me. Coercion came from a stranger. Even if a coercion comes from a stranger, it still is not a free consent. So coercion can also come from a stranger. It can also be given from a stranger. Yes, even threat to commit suicide is something amounting to coercion. Whenever you are just threatening someone that I will commit suicide if you don't listen to me, yes, it's nothing but a coercion. The person is trying to, the person is trying to enter you into a contract by force. So even threatening to commit suicide is nothing but amounting to coercion. Okay, when I'm buying the property of Aryan at rupees 100 only, when I'm buying the property of Aryan at rupees 100 only, through coercion, then can Aryan file a case against me? Yes. But can I file a case against Aryan? No. So just try to recollect a contract which is enforceable by law only at the option of one or more parties and not at the option of other parties, then such contracts are nothing but voidable contracts. So whenever there is a usage of coercion, sorry to say, it is not a valid contract, but there will be a voidable contract. Let us go on to the next part, which talks about undue influence. Section number 16 deals with undue influence. Undue influence is possible only when there is a fiduciary relationship. One of the party is under a dominating position, and that party is taking an unfair advantage of that position. So, whenever there is a fiduciary relationship, what is a fiduciary relationship? A relationship which is based upon trust and beliefs. Any relationship which is based upon trust and beliefs, then such relationships are called as fiduciary relationship. Now, 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 if there is a fiduciary relationship, and in that relationship, one of the party is under a dominating position, and that party is able to take an unfair advantage of his position, that means the person is taking the usage of undue influence and taking your consent to enter into a contract. Whenever the consent is taken by undue influence, sorry to say, it is involving a moral pressure that is nothing but a mental force. Even in case of undue influence, the contract is nothing but a voidable contract. Let me give you a very simple example. Let us talk about a relationship between parent and child. Yes, being a child, you have a complete trust upon your parents. Yes, even your parents has a trust upon you. So the relationship of a parent and a child is nothing but based upon fiduciary relationship. Now, in this relationship of parent and child, who who is under a dominating position? Yes, pretty obvious. It is the parents who enjoy a dominating position. Now, if the parents are trying to take, if the parents are trying to take unfair advantage of their positions, then in that case, whatever is the contract entered by them with you will be out of a mental pressure, a moral pressure. Then in that case, sorry to say, it is just a consent but not a free consent. There would be a contract, but there won't be a valid contract. In fact, the contract which gets formed through undue influence is voidable in nature. The consent of the child is taken through undue influence because the parents have used unfair advantage of their position. In practical life, undue influence is possible in case of lawyer and client, in case of doctor and patient, even in case of teacher and students, etc. There are many other relationships. So if you see all this relationship, one of the party is under a dominating position, and that party is also in a position to take unfair advantage. If the person takes an unfair advantage, then he has taken the consent through undue influence. See, in coercion, strangers were possible. Coercion can come from a stranger, but in undue influence, strangers are not possible. Undue influence can be exercised only by a person with whom we are having a relationship. So there cannot be a possibility of strangers in case of undue influence. How can a stranger have an undue influence upon you? Undue influence is possible only and only when there is a fiduciary relationship, which means there is involvement of trust and beliefs. We don't have a trust upon a stranger, which means there is no fiduciary relationship, hence, there cannot be a chance of undue influence. So whether the consent is taken by coercion or the consent is taken by undue influence, in any of the situation, the contract which gets formed is nothing but a voidable contract. Let us go on to the next part, that is section number 17, which talks about fraud. What is a fraud? Fraud is nothing but a false representation made willfully. If knowingly you are saying a false statement, knowingly you are speaking out a false statement, and with that you are having an intention to deceive someone, then in that case you are doing nothing but a fraud. And whenever a contract has been formed through fraud, then in that case, the aggrieved party has a right to terminate the contract, and that aggrieved party can also claim damages from the defaulting party. Sir, how can a person do fraud? A person can do fraud by actively concealing the fact, or he's making a promise without an intention to perform it, or he's having an intention to cheat someone, he's doing an activity which is declared as fraudulent by law, or he's making a statement which he himself believes is not true. So whenever you are making a statement wherein you yourself believe that it is a false statement, then also you are putting that statement, then you are trying to do a fraud one. Then you are trying to do fraud over here. I made a promise to a girl that I will marry her. I made a promise to a girl that I will marry her. But when I was making that promise, I was clearly having an intention not to marry her. Then also I'm making a promise that I will marry her. Then in that case, I'm trying to do a fraud with that girl. So what is the general idea of fraud? Fraud nothing means a false representation of a fact made willfully. I repeat, false representation of a fact made willfully, wherein the intention of the person is to deceive someone. Your intention is to deceive someone. And in that case, the aggrieved party can terminate the contract and also claim damages. But, sir, if a person is just keeping silence, then, sir, does silence amounts to fraud? Law says no. If a person is merely keeping silence, then silence does not amount to fraud. Mere silence does not amount to fraud. See, what is a fraud, first of all? Fraud means you are you are speaking out a statement which you yourself know that it is a false statement, and you have done this thing willingly with an intention to deceive someone. So if you are speaking out something which is a false statement which you know it, then also you are speaking it, then it means you are doing a fraud. But if a person is not speaking anything, then that does not mean he's doing a fraud. Mere silence does not amount to fraud. If a person is just keeping silence, then it does not mean he's doing a fraud. So the rule, mere silence does not amount to fraud. But there are two exceptional cases. One, duty to speak, and number two, your silence is equivalent to speech. In both of these exceptional cases, in both of these exceptional cases, silence amounts to fraud. Generally, silence does not amount to fraud. But if it is your duty to speak and then also you are keeping your mouth shut, then it means you are doing a fraudulent activity. One fine day, one fine day, a father bought a horse for his daughter to ride. The horse was of unsound mind. This thing was known to the father, but he did not disclose this fact to his daughter. The daughter started riding the horse and she got hurt. The daughter started making a complaint that horse is of unsound mind. Father, you knew it. Then also you gave me this horse to ride. Father said, I was just silent, and silence does not amount to fraud. Sorry to say. Sorry to say, Mr. Father, in this case you have done a fraud, because whenever there is a fiduciary relationship, it is your duty to speak. The girl was having a complete trust upon her father. The father has betrayed her. So, whenever it is your duty to speak and you are still not speaking, then in that case, silence amounts to fraud. Generally, silence does not amount to fraud. But when it is your duty to speak, and then also if you are not speaking, then in that case, silence amounts to fraud. The second exceptional case, silence itself is equivalent to speech. One fine day, I had a plan to go for a swimming. So I just went by a nearby river. Over there was a river manager. I just made an inquiry to the river manager that, hey, river manager, is this river safe for swimming? The manager just gave me a smile. I said, excuse me, I'm not asking for your smile. I'm just making an inquiry that, is this river safe for swimming? Again, the manager gave me a smile. I said, okay, if you are smiling, then I'm assuming that the river is safe for swimming. Again, the manager gave me a smile. Then what will I assume? That the river is safe for swimming. The moment I entered the river, I got the knowledge that this river is not safe for swimming. Now, 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 the river manager started saying, sir, I was just silent and silent does not amount to fraud. Hey, manager, your silence was equivalent to speech because when I made an inquiry that, is the river safe for swimming, you give a smile. I said, okay, if you are smiling, I'm assuming that the river is safe for swimming. Then also you gave me a smile, which means I can assume that the river is safe for swimming. But sorry to say, the river was not actually safe for swimming. So generally the rule says silence does not amount to fraud. But yes, in case of exceptional cases, silence amounts to fraud. Exceptional case number one, that is duty to speak, and exceptional case number two, your silence itself is equivalent to speech. The next concept over here is nothing but about misrepresentation. See, whenever you are entering a contract with fraud, then in that case, the aggrieved party can file a case against you, but you cannot file a case against the aggrieved party. Hence, the nature of contract is nothing but voidable contract. So, whether you take the usage of fraud, or whether you make the usage of undue influence, or whether you make the usage of coercion, any contracts entered by such activities are nothing but voidable in nature. The next one over here is about misrepresentation. Section number 18 of Indian Contract Act 1872 talks about misrepresentation. What is a misrepresentation? It's a false representation made innocently. It is a false representation made innocently, wherein the person making such false representation does not have an intention to deceive someone. See, there's a difference between fraud and misrepresentation. Under fraud, the person is making a statement which is a false one, and he's doing that thing willfully, knowingly. But when it comes to misrepresentation, there is a false representation made out of innocence. In case of fraud, the person is having an intention to deceive someone, but in case of misrepresentation, the person does not have an intention to deceive someone. In case of fraud, the person giving a fraudulent statement knows that the statement given by him is not true. But in case of misrepresentation, the person making the statement believes it to be true. However, later on, it turns out to be false. But the person has just given the statement out of innocence. He never knew that this is going to be turned out into a false statement. When it comes to fraud, the aggrieved party can terminate the contract and the aggrieved party can also claim damages. But in case of misrepresentation, aggrieved party can only and only terminate the contract but cannot claim damages. Because the person who has done a misrepresentation did not had an intention to deceive that other person. Hence, sorry to say, you cannot demand any kind of damages. Whenever there is a misrepresentation, the nature of contract is nothing but voidable contract. So whether you talk about coercion, whether you talk about undue influence, whether you talk about fraud, or whether you talk about misrepresentation, the contract which gets formed is nothing but voidable contract. The last part over here is mistake. Mistake means error. Section number 20 and section number 22 deals with mistake. Friends, mistakes are of two types. Number one, mistake of law, and number two, mistake of fact. When I say mistake of law, so in that case, it can either be a mistake of Indian law or it can either be mistake of foreign law. The persons have entered into a contract, and while entering into a contract, they have broken out the provisions of Indian law, and they are just stating that it was by mistake. Law says sorry to say. Law says sorry to say. Mistake of Indian law. Mistake of Indian law is not excusable. Mistake of Indian law is not excusable. Ignorantia juris non excusat. Under any circumstances, the person must have the knowledge of Indian law. However, the contract which is getting formed, is nothing but a valid contract, provided you have rectified the mistake and then you have performed the contract. We need to also punish the culprits. No? So in that case, we need to keep the status of a contract as a valid contract. So mistake of Indian law is not excusable, but the contract will be still considered as a valid contract, provided the mistake has been rectified. On the other hand, mistake of foreign law is excusable. Okay, you can have a mistake of foreign law. A person cannot be assumed to have the knowledge of law of every country. No, you cannot assume a person to have knowledge of every country. No, you cannot assume that a person will have the knowledge of law of every country. No, I'm an Indian. I will be not having a knowledge of Chinese law. I won't be having a knowledge of English law. I won't be having a knowledge of Americans law. So whenever there is a mistake of foreign law done by me, it's excusable in nature. But wait, don't perform those contracts. It is impossible to perform. Hence, it is something called as void. So mistake of Indian law, not excusable. Rectify the mistake, perform the contract, valid. Mistake of foreign law, excusable, because a person cannot be assumed to have knowledge of the law of every country. However, it is impossible to perform, hence it is void in nature. On the other hand, what is mistake of fact? That is a mistake towards the main subject matter for which the contract was formed. Mistake towards the main subject matter for which the contract was formed. Now that mistake of fact can either be a bilateral mistake of fact or it can either be a unilateral mistake of fact. When I say bilateral mistake of fact, it means both the parties are under mistake of fact. When both the parties are under mistake of fact, the contract which gets formed is void contract. See, I'm an owner of a horse. One fine day, Mr. Mukesh Ambani comes to me and he wanted to buy that horse. I and Mukesh Ambani entered a contract on 1st January morning 10 o'clock, wherein I made a promise to sell the horse to Mr. Mukesh Ambani for rupees 1000 crores. So the contract was entered on 1st January morning 10 o'clock. The contract was scheduled to be performed on 3rd January morning 10 o'clock. Now, when the contract was entered, I was under a belief that the horse is alive. Even Mukesh Ambani thought that he's buying a horse which is alive. But exactly at 8 o'clock, the horse was already been dead and I never knew that. So over here, the contract between me and Mukesh Ambani, the main subject matter of that contract was horse. I was under an impression that the horse is alive. Mukesh Ambani was also under an impression that the horse is alive, but actually the horse was dead. I never knew this. Mukesh Ambani never knew this. It was a mistake. It was a mistake done by both the parties. It is a bilateral mistake of fact. The contract is already formed, but sorry to say, now due to death of the horse, it is not possible to perform the contract. Hence, it is void contract. So when both the parties are under mistake of fact, then in that case, the contract is nothing but a void contract. But when there is a mistake of only one party is under a mistake, then why should another party suffer? When there is a mistake done by only one party, then why should another party suffer? So in that case, the contract which is formed is always and always valid in nature. So whenever there is a bilateral mistake of fact, the contract is void. Whenever there is a unilateral mistake of fact, the contract is valid in nature. Bilateral mistake of fact, void. Unilateral mistake of fact, valid. Mistake is done by only one person, na? Then let that person suffer. Let that person suffer. Why would other person suffer? So for that other person who is not ready to suffer, for him the contract is already a valid contract. So this was our entire concept towards mistake. With this, with this, we have completed our point number F, which talks about free consent. Which talks about free consent over here. So in practical life, whenever we are going to form a contract, we need to form a valid contract. And in order to form a valid contract, we need to fulfill the provisions given under section number 10. One of the provision under section number 10 was about free consent. Done. Now we are left out. Now we are left out with two more provisions, that is point number G and point number H. We will do those provisions just after a short break for 5 minutes. Thank you. Yes, friends, welcome back to the world of business law. Before the break, we had completed a topic called as free consent. Now, friends, let us go to the next topic, that is point number G, which talks about lawful consideration and lawful object. Yes, friends, in practical life, whenever we want to form a contract, we will be forming a valid contract. And in order to form a valid contract, law says that the object inside the contract as well as the consideration inside the contract shall be lawful in nature. Shall be lawful in nature. Okay. Whenever we enter into a contract, whenever we enter into a contract, can I say every contract has got some objects? Yes, every contract has got some objects, and every contract also has got some kind of consideration. So inside every contract, you will come across an object and you will also come across some kind of consideration. Okay. One fine day, I was very much hungry, so I went to a food stall called as a dosa center. The moment I went to a dosa center, I gave an order and I placed an order for having a masala dosa. The person over there said to me 40 rupees. I said, okay, done. So there was a contract between me and the dosa wala. Over here, what was the main object of entering the contract? The object from my side was to satisfy my hunger, and the object for the dosa wala was to earn profits. In a similar way, if I am giving a consideration of 40 rupees, then in return I'm getting a dosa. For dosa wala, when he's making a promise to give me a masala dosa, he's getting 40 rupees in return. So whenever there is a contract, inside every contract there is an object and there is a consideration. But whenever we want to form a valid contract, then law says that inside every contract the objects shall be lawful in nature, the consideration shall also be lawful in nature. So inside every contract the object shall be lawful as well as the consideration shall be lawful in nature. If any one of them turns out to be unlawful, then sorry to say there cannot be a valid contract. If any one of them turns out to be unlawful, then sorry to say there cannot be a valid contract. Okay. So whenever we want to form a valid contract, dash as well as dash should be lawful in nature. Very good. The answer is object as well as the consideration should be lawful in nature. Now, law says following are the situations wherein the object or consideration is unlawful in nature. So there are over here few circumstances wherein either the object or consideration is unlawful in nature. For that reason, in those circumstances, there won't be a valid contract. Pretty obvious, na? For a valid contract, what we require? Object should be lawful, consideration should also be lawful. But in this circumstances, that is in the following situations, either the object is unlawful or the consideration is unlawful. Hence, there cannot be a valid contract in those circumstances. Number one, agreement in forbidden by law. Whenever there is an agreement being formed which is forbidden by law, which is against the law, pretty obvious it is having an unlawful object, hence there cannot be a valid contract. Second, agreements defeating the provision of law. Whenever you are asking someone to do something against the law, which means there is an unlawful object again, then in that case also there cannot be a valid contract. Involving or causing injury to a person or his property. Whenever you are making a contract with a person wherein you are asking that person to give an injury to a person or his property, to another person's property or to another person. For example, I entered an agreement with Karthik and I told to Karthik that Karthik, I will pay you 10 lakhs rupees if you injure Aryan. You need to just injure Aryan, break his head, break his hand, break his legs. I will pay you 10 lakhs rupees. Karthik said, okay, so done. So the agreement between me and Karthik is going to provide an injury to a person called as Aryan, which is having an unlawful object. Hence, there cannot be a valid contract between me and Karthik over here. Next, consideration is immoral in nature. Yes, already we have done this thing again in consideration. That consideration should not be immoral. Consideration should not be opposed to public policy. Consideration should not be unlawful in nature. So over here, whenever consideration is immoral in nature, it is considered as unlawful consideration. Sorry to say, there cannot be a valid contract. Next, object of the contract is fraudulent. Whenever the object is fraudulent, the object itself becomes unlawful in nature. Hence, in that case, also there cannot be a valid contract. For example, I, Karthik, and Aryan, we three started a business in a form of a partnership. The object of our business was to do fraud with the people living in India. So over here, can I say our main object is to do fraud with people living in India? And through that object, we have incorporated a firm. We are doing a business in a form of a partnership firm. Then sorry to say, whatever is the agreement between me, Karthik, and Aryan, that agreement is not lawful in nature. It is unlawful in nature. Hence, there cannot be a valid contract. Last, any such activity which is opposed to public policies. See, what are public policies? Public policies are generally which are there for the benefits of people at large. However, any such things which is done against public policies are considered to be opposed to public policies. See, following are the situations which are opposed to public policy. So in all these situations, there won't be a valid contract because they are nothing but opposed to public policies. And whenever they are opposed to public policies, it is having an unlawful object or an unlawful consideration. Hence, there cannot be a valid contract. Number one, trading with enemy nations. Whenever there is a war between India and Pakistan, for example, there is a war between India and Pakistan, which means every citizen of Pakistan will be considered as our enemy. And if you are having a trading agreement with those persons who are nothing but our enemy nations, then it is opposed to public policy. Sorry to say, there cannot be a valid contract in that case. Next, trafficking in public offices. Whenever you are providing some kind of bribes in order to get your work done, you are providing some kind of bribe at the public offices in order to get your work done, then again in that case, the agreement between you and the officer to whom you have provided that bribe is considered as opposed to public policies. And sorry to say, there cannot be a valid contract between you and that officer. Next, interference with the course of law and justice. Whenever you are interfering into the course of justice, whenever you are interfering into the course of law and justice, which means you are poking your nose into the working of the law and justice. Sorry to say, then in that case, whatever is the agreement between you and the judge, then in that case, there won't be a valid contract. It is opposed to public policy. For example, you are providing some kind of a bribe to a judge. The judge kindly give a judgment in his favor or in his favor or in my favor, etc., etc. Then you are trying to interfere, with the working of the court itself. It is considered to be opposed to public policy. In that case, there won't be a valid contract. Next, stifling prosecution, which means you are trying to give a bribe to the witness of the court. You are trying to change the statement of the witness of the court. Then even in that case, it is opposed to public policy. Sorry to say, there cannot be a valid contract over here. Any kind of marriage brokerage contract, you are providing some kind of money to a person in case of marriage contracts. Sorry, there cannot be a valid contract. It is opposed to public policies. Example, dowry. It is opposed to public policy. There cannot be a valid contract. Agreements creating monopoly. See, what is a monopoly market? When I say monopoly market, it means there is a single seller and there are multiple buyers. When there is a single seller and there are multiple buyers, then in that case, the single seller is in a position to ruin the entire market. He can play a dominating position wala role, and he can also take unfair advantage of that position. So any agreements wherein you are trying to create a monopoly, then sorry to say, those agreements are opposed to public policy, and in that case, there won't be a valid contract. Last, Agreements towards maintenance and champerty. What is maintenance? Maintenance means to file a case indirectly, to maintain a suit indirectly. Over here, I was very much jealous of a person called as Mr. Shah Rukh Khan. I wanted to defame him. I wanted to defame him. So what did I do? I just approached a girl and I just told to the girl that you file a fake case against Shah Rukh Khan, that Shah Rukh Khan has misbehaved with you. Actually, he had not done this thing, but you just file a fake case against him so that the goodwill of Shah Rukh Khan gets defamed. Over here, the girl said, okay, I'll do it, but what will I get in return? I said, I will pay you 5 crores. Now, the girl is ready to file a case against Shah Rukh Khan, but not for justice, but for money. So, any agreements when you are trying to maintain a suit indirectly, they are opposed to public policies. Sorry to say, there won't be a valid contract. Similarly, in case of champerty, what does champerty means? Champerty means you are assisting someone to file a case. You are assisting someone to file a case. And in return, you are demanding the share in the proceeds of the court. You are assisting someone in filing a case, and in return, you are demanding a share in the proceeds of the court. See, assisting someone in filing a case is a very good activity. But in return, if you are demanding a share in the proceeds of the court, that is something which is opposed to public policy. Hence, there won't be a valid contract. So, these are the situations which are opposed to public policies, and yes, there won't be a valid contract. Last point, and we are about to wind up our topic number 3, how to form a contract. So, in practical life, whenever we are going to form a contract, we wanted to form a valid contract. Now, law says, in order to form a valid contract, the agreement inside that valid contract should not be expressly declared as void by law. Because if the agreement itself is declared as void by law, sorry to say, there won't be a contract. And if there is no contract, how can there be a chance of a valid contract itself? See, can I say inside every contract, there is an agreement which is enforceable by law. Any agreement enforceable by law is a contract. Now, if I say that this is an agreement declared as void by law, when the agreement itself is void, there won't be a contract. And when there is no contract, how can there be a valid contract? So whenever you are going to form a valid contract, the agreement inside that valid contract should not be declared as void by law. Because if the agreement itself is void, there won't be a contract. And if there is no contract, how can there be a question of a valid contract? If the agreement is declared as void, means they are declared as void by law. They are void from the beginning. See, there's a difference between void contract and void agreements. When I say it was valid, later on it has become void, then it is a void contract. But if I say it is void from the beginning, which means it is void ab initio, it is nothing but void agreements. That is section number 2G, which we have already done in our yesterday's lecture. So any agreements which are expressly declared as void by law, those agreements are actually void ab initio. When the agreement itself is void, there cannot be a contract. And if there is no contract, how can there be a question of a valid contract? Sir, are there any agreements declared as void by law? Yes, there are many agreements declared as void by law. See over here. Agreements in restraint of marriage, agreements in restraint of trade, agreements in restraint of legal proceedings, uncertain agreements, wagering agreements. All those agreements are agreements which are declared as void by law. When the agreement itself is declared as void by law, there cannot be a contract. And when there cannot be a contract, how come there be a question of a valid contract? So one last time. Whenever you want to form a valid contract, then inside that valid contract, there is an agreement. That agreement should not be declared as void by law. If that agreement is declared as void by law, sorry to say, there won't be a contract. And if there is no contract, there cannot be a question of valid contract itself. Sir, which are the agreements which are declared as void by law? The very first one, section number 26 says agreements in restraint of marriage. Any agreement, any agreement wherein you are restraining a person to get married. Any agreement wherein you are stopping a person to get married, then in that case, the agreement between you and that person is something called as void agreements. There cannot be a valid contract. One fine day, Mr. X approaches to Mr. Y and says, "Hey, Mr. Y, if you promise me that you are not going to get married, then I will pay you 10 crores. So, through this agreement, Mr. X is trying to stop Mr. Y from getting married. It is an agreement in restraint of marriage. Sorry to say. Any agreement wherein you are stopping a person to get married, those agreements are void ab initio. When the agreement itself is void, there cannot be a contract, and if there is no contract, there cannot be a question of a valid contract over here. So the rule, agreements in restraint of marriage, allowed, not allowed, not allowed. You cannot stop a person from getting married because it is his fundamental right to get married. So any agreement wherein you are stopping a person to get married, any agreement wherein you are stopping a person to get married, then those agreements are not allowed. But if that agreement is with a minor, or if this agreement is only for a reasonable period of time, then they are considered as allowed. Generally, you cannot stop a person from getting married, it is not allowed. But if you are stopping a person which is a minor, then yes, in that case, the agreement is valid. However, if you are stopping a person to get married for a reasonable period of time, then even in that case, that agreement will be considered as valid one. For example, Mr. X said to Mr. Y, if you don't marry for next 6 months, I will pay you 10 lakh rupees. This is something which is reasonable in nature. If you're stopping a person for not getting married for a reasonable period of time, then yes, it will be considered as valid in nature. What is reasonable? It is not defined. It keeps on changing from person to person, situation to situation, time to time. So, section number 26. Agreements in restraint of marriage, not allowed. But in case of minor or in case of a reasonable period of time, it will be considered as allowed. The second one, section number 27. Agreements in restraint of trade. Law says you cannot stop a person from doing a trading activity. You cannot stop a person from doing a trading activity. Any agreement wherein you are stopping a person from doing a trading activity, then that agreement between you and that person is void ab initio. When the agreement itself is void, there cannot be a contract, and if there is no contract, there cannot be a valid contract as well. So any agreement wherein you are stopping a person from doing a trading activities, sorry to say, it's not a valid agreement. When the agreement itself is not valid, there won't be a contract, and if there is no contract, the question of valid contract does not arise. So make a rule. Make a rule. Can you stop a person from doing a trading activities? No. No, you cannot stop a person. So any agreements wherein you are stopping a person from doing a trading activities, those agreements are not allowed. But if it is a case of sale of goodwill, partnership agreements, trade combinations, service contracts, in these four exceptional cases, if you are stopping a person from doing a trading activities, then yes, it is considered as valid in nature. Generally not allowed, but in these four exceptional cases, they are allowed. If a person is selling his goodwill, which means the person buying the goodwill has paid some premium amount to buy that goodwill. The person who has bought that goodwill can restrict the seller from doing a specific trading activity, provided it is reasonable in nature. Provided it is reasonable in nature, it will be considered as valid. Second exceptional case, in case of partnership agreements, The partner of a firm can restrict another partner from doing specific business activities, and those restrictions are allowed in nature. It is not considered as void, it is considered as valid. So, partner of a firm can stop another partner of the same firm from doing a particular activity, from doing a particular business activity. It will be considered as allowed, it is valid in nature. Third, in case of trade combinations. For example, few wholesalers of mango, the wholesalers dealing in mangoes comes together and they make a trade combination that we will never sell mangoes below 400 rupees per dozen, which means we are not allowed to sell mangoes below 400 rupees per dozen. Over here, we are restricting them not to sell mangoes below 400 rupees per dozen. Law says it is allowed because it is something called as a trade combinations. Last, service contracts. Service contract is a contract between an employer and an employee, wherein the employer has a right to stop an employee from doing certain types of trading activities. Those agreements are again considered to be valid in nature. Generally, can you stop a person from doing trading activities? Law says no, not allowed. But if it is a case of sale of goodwill, or it is a case of partnership agreement, or it is a case of trade combination, or it is a case of service contracts, then in that case, the agreement wherein you have stopped a person from doing trading activities will be considered as valid in nature. Generally not allowed, but in exceptional cases allowed. Next, section number 28, agreements in restraint of legal proceedings. Law says you cannot stop a person from going to a court. You cannot stop a person from filing a legal proceedings. Any agreement wherein you are stopping a person to file a legal proceeding, then that agreement is void ab initio. Any agreement wherein you are stopping a person to go for legal proceedings, then that agreements are not allowed. I am a principal and I entered a contract with the agent. And I said to that agent that I will pay you commission of 10%. Whatever are your expenses at the outstation branches, all those expenses shall be borne by me. But just give me a promise that if at all I do a breach of contract with you, then you won't file a case against me. See, through this last condition, the principal is trying to stop the agent from filing the case. Law says this is not allowed. Any agreement wherein you are restraining a person from filing a legal proceedings, sorry to say, that agreement is void ab initio. When the agreement itself is void ab initio, there won't be a contract. And if there is no contract, how can there be a question of a valid contract? So fast, can you stop a person from filing a legal proceedings? The law says no, not allowed. But if it is a case of jurisdiction or if it is a case of arbitration, then it is allowed. What is jurisdiction? Over here in jurisdiction, the person is stopping a person to file a case at a particular court. The principal said to his agent, kindly don't file a case against me at Delhi. If you want to file a case against me, you can file a case against me at Mumbai, but don't file a case against me at Delhi. The principal did not restrict the agent to file a case. However, the principal has just restricted the agent not to file a case at Delhi. So that's a particular jurisdiction, particular area, particular court. It is allowed. If you are stopping a person to file a case, not allowed. But if you are stopping a person to file a case at a particular court, allowed. Next exceptional case, arbitration, which means out of court settlement. The courts in India are themselves saying that it is better to go for arbitration before approaching to the court. So if the principal and agent have come together and they have agreed that let us not go to the court and let us settle the matter through arbitration, law says it is allowed. It is allowed. Generally, if you are stopping a person to go for court activities, it is not allowed. But in case of jurisdiction and in case of arbitration, it is allowed. So section number 26, agreements in restraint of marriage, not allowed, but in exceptional cases allowed. Section number 27, agreements in restraint of trade, not allowed, but in exceptional cases allowed. Agreements in restraint of legal proceedings, not allowed, but in exceptional cases allowed. Similarly, section number 29, uncertain agreements. Any agreement wherein the offer is uncertain or the acceptance is uncertain, it is an uncertain agreement, and sorry to say, uncertain agreements are void ab initio. I made a promise to sell oil. Which oil I don't know. It is an uncertain offer from my side. The agreement which gets formed is an uncertain agreement. Over here, it is void ab initio. Last, wagering agreements. Any agreements which are towards betting transactions. Any agreements which are towards betting transactions are called as wagering agreements, wherein the main object is either winning or losing. The main object is either winning or losing. So, wagering agreement is an agreement involving payment of a money upon determination of an uncertain event. If the uncertain event happens, pay me the money. If the uncertain event does not happen, don't pay me the money. The main importance towards a wagering agreement is nothing but either to win or to lose. If there's a match between India and Pakistan, and I say India wins, you say no, Pakistan will win. I said no, 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 India will win. You said no, no, Pakistan will win. I said okay, let us go for a bet. If India wins, you pay me 1 lakh. If Pakistan wins, I will pay you 1 lakh. Then the transaction which is getting entered between me and you is a wagering agreement. Wherein if India wins, you pay me 1 lakh. India loses, I will pay you 1 lakh. So that's a wagering agreement. So it is an agreement wherein a person will pay money or the person will pay money's worth. Either you pay me money or you pay me in money's worth. I said, okay, if India wins, you give me iPhone 12. If India loses, I will give you iPhone 12. So there is no involvement of money. It is an involvement of money's worth. So either there is an involvement of money or there is involvement of money's worth. Promise must be conditional on an event happening or non-happening. If India wins, it is happening for me, non-happening for you. If Pakistan wins, it is happening for you, non-happening for me. Yes, the event must be uncertain. I don't know who is going to win. Even you don't know who is going to win. Either India can win or Pakistan can win. So there is completely an uncertain event. There must be two parties. Yes, there are two parties, wherein each party must tend to win or lose. Either I will win or you will win. Either I will lose or you will lose. The common interest is having an intention to bet. There is a betting transaction. No? Over here, the party should have no interest in the event except for stake. Whatever is the money being involved, that is the only interest we're having. Nothing else is the interest over here. Law says wagering agreements are always and always void. Yes, wagering agreements are always and always void. But something which is collateral to wagering are valid. I and you entered into a wagering agreement, it is void. But now India wins the match, Pakistan loses the match. So can I say you will have to pay me 1 lakh rupees? You don't have 1 lakh rupees. So you have approached to your friend to get a loan of rupees 1 lakh. So whatever is the transaction between you and your friend, it is collateral to the transaction between me and you. So if wagering agreement between me and you is void, then the collateral one between you and your friend is valid in nature. Which means if you have taken a loan of rupees 1 lakh, you gave that money to me, I got discharged. But now it is your duty to repay the loan of 1 lakh back to your friend. If you don't repay that 1 lakh back to your friend still has a right to file a case against you for breach of contract. So wagering agreements are void, but collateral to wagering are always and always valid. All illegal agreements are void. This we have already done in our yesterday's lecture. Illegal agreements are void, and collateral to illegal are also void. Collateral to illegal are also void. Anything which is illegal is always and always void. But anything which is collateral to illegal is also considered to be void. What is collateral? Related. Over here, I and you entered into a contract wherein I said, okay, you kill Mr. X, I will pay you 5 crores. You kill Mr. X, I will pay you 5 crores. It is illegal, na? It is illegal to kill someone. You killed him. You killed Mr. X, and now I'm liable to pay you 5 crores. I don't have money, so I'm going to a banker and I'm asking for a loan of 5 crores. I said I'm having an obligation to pay 5 crores. I made a promise to pay him 5 crores because he was going to kill Mr. X. He has already performed his part. Please give me 5 crores. I will repay you later. The collateral agreement between me and a banker will also be considered as void in nature. It is illegal in nature, rather. So, whatever is illegal is always void. Whatever is collateral to illegal is also illegal. That is void itself. So, collateral stands for something which is related in nature. So, just make a rule: wagering, void. Collateral to wagering, valid. Anything which is illegal is always void, and anything which is collateral to illegal is also illegal, and that is nothing but void in nature itself. So with this, friends, we have completed our Roman number 3, how to form a contract. Let us go on to the next part, that is Roman number 4, how to perform a contract. How to perform a contract. Friends, when I talk about performance of a contract, so always have a thing, always and always have a thought process that the contract is already formed now, but now we are talking about the performance of that contract. See, the entire Indian Contract Act was been designed into 5 parts. Number 1, what is contract? Number 2, types of contract. Number 3, how to form a contract. 3 parts are already been done. Let us go on to the 4th part, how to perform a contract. When I say how to perform a contract, then in that case, we have to study 6 different topics. Number 1, performance of a contract. Number 2, devolution of joint liabilities and rights. Number 3, time, place, and manner of performance. Number 4, reciprocal promises. Number 5, assignment and succession. Number 6, appropriation of payments. These are the 6 topics which are associated towards Roman number 4, performance of a contract. Let us look upon the very first point, performance of a contract. Whenever I talk about performance of a contract, I'm actually talking about section number 37, 38, 39. So henceforth, whenever I'm going to shout out the words called as performance of a contract, the very first thing which is going to run in your mind is section number 37, 38, 39. 37, 38, 39. 37, 38, 39. Section number 37 says both the parties are ready to perform the contract. When both the parties are ready to perform the contract, law says it is actual performance. For example, I and Karthik had already entered into a contract for buying and selling of the car. The contract was entered on 1st January and the contract was scheduled to be performed on 10th January. So 10th January is the due date of performing the contract. 10th January is the due date of performing the contract. Now, on 10th January, I, as a promisor, went to Karthik and I said to him, Karthik, today is the due date of performance. Should I send you my car? I am giving an offer of performance. I'm giving an offer of performance. I'm not giving an offer, man. The contract is already been formed. I'm giving an offer of performance. When I say, should I send you my car, which means I'm ready to perform. On the other hand, Karthik said, yes, sir, yes, sir. Kindly send me the car. I'm going to send you 10 lakh rupees. Through this communication, it is very much clear. It is very much clear that promisor, Mr. Kunal Shah, is ready to perform. Promisee, Mr. Karthik, is also ready to perform. And when both the parties are ready to perform, it is called as actual performance. Sir, if both the parties have already performed, it is executed. Now then, the contract has come to an end, executed contract. So when both the parties are ready to perform, it is an actual performance. Promiser, ready to perform. Promisee, ready to perform. Both the parties are ready to perform actual performance. Section number 38. Promisor is ready to perform, but promisee is not ready to perform the contract. So can I say promisee is trying to do a breach of contract? Promisee is trying to do a breach of contract. In that case, Promiser will now not perform now because he has already got the knowledge that I am ready to perform, but promiser is not ready to perform. Then why should I perform? But promiser at least give an attempt to perform, but he could not perform because the promisee has refused to perform. Now, on 10th January, that is the due date of performance, I went to Karthik and I said to him, hey Karthik, today is 10th January, the due date of performance. Should I send you my car? Should I send you my car? Which means the promiser Kunal Shah is ready to perform. I give an offer of performance. Karthik said, no, sir. No, sir. Don't send me the car. I'm not going to pay you 10 lakhs. Which means Karthik is doing a breach of contract. Karthik is doing a breach of contract. But I at least gave an attempt to perform the contract. Hence, it is called as an attempted performance. Hence, it is called as an attempted performance. So when promiser is ready to perform, but promisee is not ready to perform, it is an attempted performance. Over here, the offer of performance, law says the offer of performance should be unconditional, which means at the time of performance, you should not keep any conditions. I cannot say now on 10th January that if it rains today, then only I will sell you my car. If it does not rain, I won't sell you my car. No, sorry. The contract is already been formed. Now you have to just perform the contract. So at the time of performance, the performance should be unconditional. The performance must be done at a proper time and place. That is, whatever is the time fixed, whatever is the place fixed, kindly perform the contract at that time and at that place. If the time was not fixed, then the performance should be done within a reasonable time. What is reasonable time? Not defined. It keeps on changing from person to person, time to time, situation to situations. So, if the time of performance has been fixed, perform at that time, perform at that place. If the time of performance is not specified, perform the contract within a reasonable time. Over here, reasonable opportunity for inspection. Yes, it is the duty of the promisor to provide a reasonable opportunity for inspection to the promisee. When I'm going to deliver the car to Mr. Karthik, then at that time, I should give a reasonable opportunity to Mr. Karthik to inspect my car. I should give a reasonable opportunity of inspection to Mr. Karthik to inspect my car. If he feels that it is fit, then he will buy it. He will pay me for that car. If he feels, no, the car is already been damaged. When the contract was entered, at that time the car was fit, but now the car is unfit, then he can refuse to perform as well. Whenever a person refuses to perform, then in that case, the other party can either terminate the contract. The other party can either terminate the contract, or the other party can still make the contract continue in nature. So it is the option given to the aggrieved party over here. That is nothing but section number 39. Let us go on to the second point, which talks about devolution of joint liabilities and joint rights. The meaning of the word devolution stands for transfer. Devolution stands for transfer. When I say joint liabilities, then it is a contract involving more than one promisor. Sir, can there be more than one promisor? Yes. And when there is more than one promisor, they are called as multiple promisors. In a similar way, if inside a contract there is more than one promisee, it is called as multiple promises. For example, we four professors of CA foundation course has given a promise to the entire batch of yours that you clear your foundation exams and we will pay you 10 lakh rupees. We four professors have made a promise to your entire batch that you clear your foundation exams and we will give you a payment of rupees 10 lakhs. Who has made the promise? We four professors. So there are four promisers, and this promise is given to an entire batch of 160 students, which means there are 160 promisees. So whenever there is more than one promisor inside the contract, it is multiple promisers that are joint promisers. Whenever there is more than one promisee, then in that case, it is multiple promises, that is joint rights. Let us first understand section number 42, which talks about devolution of joint liabilities. Law says when all the promises are alive, then the contract shall be performed by all of them. See, we four professors had made a promise to pay you all a sum of rupees 10 lakhs if you clear your CA foundation exams. So there's a contract between the professors and students. You all students have cleared your exams. Now it is our obligation to pay you 10 lakhs. If we all four are alive, then all of us will have to perform the contract jointly, which means I will be having a liability of 2,50,000 rupees. Professor number 2 will be having a liability of 2,50,000 rupees. Professor number 3 will be having a liability of 2,50,000 rupees. And Professor number 4 will also have a liability of 2,50,000 rupees. Which means there will be 10 lakhs rupees and this money will be handed over to you all. That is a batch of 160 students. So if all the promisers are alive, then the contract shall be performed by all the promisers jointly. But however, if one or more promiser dies, when the contract was entered, at that time all of us were alive. But now at the time of performance, one or more promiser died. For example, after the contract got entered, but before performance, I died. The result has arrived. You all have cleared your exams. So can I say you all are having a right to demand 10 lakhs rupees from us? Professor 2, 3, and 4 will shell out 2,50,000 rupees each and give it to you all. But the total sum of money is only 7,50,000. Now the balance 2,50,000 rupees will be recovered from my legal representatives. So, when one or more promiser dies, the contract will still be performed by the surviving promisers along with the legal representative of the deceased promiser. Sir, will your legal representative perform the contract? Yes, he is bound to perform the contract. If my legal representative is accepting my assets, then he also need to accept my liabilities. If my legal representative after my death is accepting my assets, then he also need to accept my liabilities. Last, law says if all the promisers have died after the contract got formed, we all four professors died. You all have secured full marks. You all have secured good marks in your CA foundation exams, which means you have cleared your exams. So you are having a right to demand 10 lakhs rupees from us. So now, we all professors have already been died. Now, law says when all the joint promiser dies, the contract shall be performed by the legal representatives of all the promisers. My legal representative will shell out 2,50,000 rupees. Similarly, the legal representatives of Professor 2, 3, and 4 will also shell out 2,50,000 rupees each, and the contract will be performed. You just make a note, na? You just make a note over here. Once the contract is formed, even the death could not stop the performance of a contract. The contract will be performed by the legal representatives, provided it is not involving personal skills and personal taste. If there is an involvement of personal skills or personal taste, then sorry to say, it is not possible to get performed by the legal representatives. Next, section number 43. What does section number 43 says? Section number 43 says that promisee can compel any one of the promiser to perform the contract. Yes, promisee is a party of rights. Being a party of rights, promisee can compel any one of the promiser to perform the contract. And the promiser who is being compelled to perform the contract, that promiser will perform the whole contract and not the part of the contract. See, this will be very much easy with the help of the example. Over here, Mr. A, Mr. B, and Mr. C, they have jointly taken a loan of rupees 30 lakhs from Mr. D. So these three persons have made a promise to Mr. D that you give us a loan of 30 lakhs, we shall repay you the money within 15 days. So these three are nothing but joint promisers, and Mr. D is nothing but the promisee. Now, 15 days have expired. 15 days have expired. So after 15 days, can I say Mr. D is having a right to demand his 30 lakhs rupees back? Okay. So law says, Mr. D, you are a party of rights. You can demand back this money. You can demand back this money from any one of the promisers. You can compel any one of them to perform the contract. So D said, okay, I'm approaching to C. Hey C, perform the contract. Which means C will have to perform the whole contract. C will have to repay entire 30 lakhs rupees to Mr. D. But sir, C was one of the joint promisor. He was liable for only 10 lakhs, but you are asking him to pay 30 lakhs. Yes. The moment C pays 30 lakhs to D, then after that, C can recover 10 lakhs rupees from B, and that C can also recover 10 lakhs rupees from Mr. B. So promise C can compel one of the promisor to perform the contract, and that promisor shall perform the whole contract and not the part of a contract. That was section number 43. Let us go on to section number 44. Section number 44 says promisee can release one of the promisor. Promisee can release one of the promisors, which means what? Being a party of rights, he has a right to release one of the promisor. D over here is having a right to recover 30 lakhs either from A or from B or from C or jointly. Whatever he wants, he can do it. He's a party of rights. Mr. D thought, I will not get the money from C. I'm releasing him from his obligations. So D is not going to demand money from Mr. C. So pretty obvious, D can now demand money either from A or from B. D caught Mr. B and he said, hey Mr. B, perform the contract. So as per section number 43, can I say B will have to perform the whole contract, which means B will have to pay entire 30 lakhs to Mr. D. The moment B performs, now B has got a right to recover 10 lakhs rupees from A and 10 lakhs rupees from C. Can now C say that I was already been released, hence you cannot demand money from me? No, C cannot say these words to B, because what will the B say over here? B will say that you were been released by Mr. Delhi, not by us. You were been released by Mr. Delhi, not by us. So this is something which is not possible in practical life. What is the law trying to see over here? Law is trying to say that promisee can release one of the promisor, and the promisor who has been released, that promisor is not liable to the promisee, but that promisor is still liable to other promisors. That promisor is still liable to other promisors. That is section number 44. The next part, which talks about time, place, and manner of performance. So there are three things to be studied over here. First, we need to understand the time of performance. Then we need to understand the place of performance. And then we need to understand the manner of performance. Let us first understand time of performance. The concept of time of performance is given under section number 46, 47, 48. So henceforth, whenever I talk about time of performance, the very first thing which is going to run in your mind is section number 46, 47, 48. What is section number 46 saying? Section number 46 saying time for performance of promise where no application is to be made and no time is specified. Means what? The promisee is not going to demand performance, and the time of performance is also not specified. The time of performance is also not specified. Then in that case, what shall be done? See, in every contract, can I say there are two parties? In every contract, there are two parties. One is the promisor, another is the promisee. Out of both of them, it is the promisor who shall perform first, because he is the party of obligation. Later on, the promisee performs. Now, law says promisor will perform, but when promisee demands. If promisee is not demanding and the time of performance is also not given, then in that case, when will the promisor perform? Then law says in that case, the promisor will have to perform within a reasonable time. So if the time of performance is not given, promisee is also not going to demand performance, then in that case, the promisor will perform the contract as per the reasonable time. And you already know reasonable time is a time which cannot be defined. It keeps on changing from person to person, situation to situation. time to time. Over here, there is a contract between me and Karthik, wherein I am the promiser, Karthik is the promisee. I have to deliver the car to Karthik, and Karthik is going to pay me 10 lakh rupees. But inside the contract, nothing has been written that when Karthik demands, then only I will sell the car. Nothing is written. Not even the time is written that when should I perform the contract. Then in that case, law says the contract should be performed within reasonable time. And reasonable time is a time which is not specified. It is a time which is not defined. It keeps on changing from situations to situations. Section number 47. Section number 47 says that the day of performance is specified, that on this day you have to perform. But on that day, at what time? Not specified. On that day, at what time? Not specified. For example, I and Karthik entered into a contract. It was been specified inside the contract that Kunal Shah will deliver the car on 10th January. Okay, the day of performance is 10th January. But now on 10th January, at what time should I perform? Morning 4 o'clock? Afternoon 4 o'clock? Midnight 3 o'clock? No, nothing. The time is not specified. The law says when the day of performance is specified, but the time on which it has to be performed is not specified on that day, then in that entire day, you have to perform during the usual hours of business. You have to perform during the usual hours of business. So what is section number 47 trying to say? 47 is trying to say, day of performance specified, sir. But on that day, at what time? Not specified. Then kindly perform the contract on that day during usual working hours. Last, section number 48. Section number 48 says that inside the contract it has been specified that the promiser will perform only when promisee demands. So unless and until promisee does not demands performance, promiser won't perform. So now it is the duty of promisee to demand performance. The moment promisee demands, then only the promiser will perform. One fine day, a caterers wala guy, a caterers wala person came to me and he said to me, sir, in your marriage, I would like to give you catering services. I said, okay. You are the promiser and I am the promisee. You have given me the offer. I have accepted your offer. You are the promiser. I am the promisee. I said to him that, okay, you give me the services of catering, but you should start serving the food only when I tell you. So in this case, the promisor will perform the contract only when I, as the promisee, demands the performance. So now it is the duty of me to demand for performance, to apply for performance. The moment I demand, the promiser, that is the caterers wala person, will perform the contract. Till that time, he won't perform the contract. So this was the provision towards time of performance. The last part towards place and manner of performance. Law says, if inside the contract, the place of performance is already been specified, then in that case, the contract should be performed at that specified place only. If inside the contract it has been specified that the contract should be performed at Bangalore, then the contract will be performed at Bangalore only. So if the place of performance is specified inside the contract should be performed at that place only. But sir, if place of performance was not specified, then in that case, law says, in that case, the promiser will go to the promisee and say, please tell me at which place should I perform. The moment promisee tells about the place, the promiser will perform at that place only. So, if the place of performance is specified, perform at that place. If the place of performance is not specified, the promiser will apply to the promisee. The moment the reasonable place is being directed by the promisee, then at that place only the promiser shall perform the contract. Last, section number 50, manner of performance. Law says the contract should be performed in the manner specified inside the contract. If inside the contract it has been mentioned, the promisor will perform first, later the promisee will perform. perform the contract as per the manner given. If inside the contract it has been specified, the performance will be given by promisee and later on by the promiser, then in that case, perform the contract as per the manner given. Let the promisee perform first and later the promiser performs. So the manner of performance simply tries to say that you have to perform the contract as per the manner prescribed inside the contract. Generally, it is the promisee who prescribes because promisee is the party of rights. So prescribed by the promisee because promisee is the party of rights. Are you sure? So friends, this was towards time, place and manner of performance. Over here, under Roman number 4, over here under Roman number 4, friends, we have completed 3 topics. Now we are left out with balance 3 topics, and after that we are left out with the last topic, that is how to discharge a contract, which means in today's lecture itself we are going to complete our Indian Contract Act 1872. Friends, let us go for a break for 5 minutes, and we'll be right back just after the break. Thank you. Yes, friends, welcome back to the world of business law. Before the break, we had already commenced our topic called as Roman number 4, how to perform a contract, wherein we had to discuss 6 different topics. Out of them, 3 are already been discussed. Let us move on to the next topic, that is topic number 4, which talks about reciprocal promises. Yes, friends, reciprocal promises. What do you mean by reciprocal promises? Law says a promise which forms the consideration or part of consideration for each other are called as reciprocal promises. In short, in a plain English meaning, reciprocal promises are promises made against a promise. I repeat, reciprocal promises are promises made against a promise. In practical life, at most all the times, in practical life, in at most all the times, we enter into a reciprocal promise. For example, when I had a contract with Karthik, wherein there was my promise to sell the car. And in return, Karthik gave me a promise that he is going to pay me 10 lakh rupees. So for my promise to sell the car, I got a promise that is that I'm going to receive 10 lakh rupees. So reciprocal promise is a promise made against a promise. Wherein, if I am making a promise to sell the car and Karthik is making a promise to pay me 10 lakh rupees, which means only I will have to perform? No. Only Karthik will have to perform? No. Both the parties has to perform, which is nothing but bilateral contracts. So whatever are bilateral contracts, they are actually nothing but reciprocal promises. That is a promise made against a promise. I repeat, promise made against a promise. Now, whenever you talk about a reciprocal promises, then yes, they have to be performed. And yes, reciprocal promises can be performed by 3 ways. There are 3 ways by which a reciprocal promise can be performed. Number one, it can be performed mutually and concurrently. When I say reciprocal promise is going to get performed mutually and concurrently, then it means both the parties are going to perform simultaneously. Both the parties are going to perform simultaneously. Over here, I and Karthik entered into a contract, wherein inside the contract, it is my promise to sell the car and it is Karthik's promise to pay me 10 lakh rupees. We have decided that let us perform this contract mutually and concurrently. On 10th of January, I will hand you the keys of the car and you hand me 10 lakh rupees. So both the parties, see, mutual stands for both. Concurrently stands for simultaneously. So both the parties are going to perform the contract simultaneously. However, reciprocal promise can also be performed independently. When I say reciprocal promise is going to be performed independently, it means promisor is going to perform his obligation, promisee is going to perform his obligations, and both of them are going to perform, and their performances are not dependent upon each other, which means they are independent in nature. One fine day, I wanted to purchase 5,000 kgs of rice. So I went to a farmer and I said to the farmer that I would like to purchase 5,000 kgs of rice. Farmer said, okay, price per kg is 100 rupees. I said, okay, I promise to pay you 5 lakh rupees. Farmer said, okay, I promise to sell you 5,000 kgs of rice. The contract got entered on 1st of January and the contract was scheduled to be performed on 30th June. So there was a time gap of 6 months between the date of forming the contract and the due date of performance. It is my promise to pay him 5 lakhs and it is the promise of the farmer to deliver me 5,000 kgs of rice. Over here, it is me who will independently work in order to raise the funds of 5 lakhs. I won't wait for the performance of farmer. I won't think in such a way that farmer will first give me 5,000 kgs of rice, then I will think from where should I get 5 lakh rupees. No, I will perform my part independently. In a similar way, farmer's performance is not dependent upon my performance. Farmer won't say that only when Kunal Shah shows me 5 lakh rupees, then only after that I will think from where should I get the seeds for the rice, how will I cultivate them, and how will I cut them, how will I parcel them. I will do all these things later on. No. The performance of the farmer is not dependent upon the performance of Kunal Shah. In a similar way, the performance of Kunal Shah is not dependent upon the performance of farmer. Both the parties are going to perform independently. So, reciprocal promise can be performed mutually and concurrently. Number two, reciprocal promise can also be performed independently, wherein the promisor will perform his part, promisee will perform his part. The performance of promisor is not dependent upon the performance of promisee. In a similar way, the performance of the promisee is not dependent upon the performance of the promisor. Both the parties are performing but independently. Last, reciprocal promise can be performed conditionally and dependently. Reciprocal promise can be performed conditionally and dependently, which means which means the performance of the promisor is depending upon the performance of the promisee, which means the promisee will perform first and later on the promisor shall perform. One fine day I gave a general offer in the market. See, I am a courier company. I gave a general offer in the market that any company who wants to transport their goods through my company, I will give you discount of 30% in freight charges, transportation charges. So my offer is to give a discount of 30% upon freight charges, that is the transportation charges. One company is approaching me and they are saying to me, okay, we are ready to send you millions and tons of goods and which you have to transport from this country to another country. I said, okay, I promise to give you a discount of 30% on the charges. So my promise to give a discount is first depending upon his promise to deliver the goods to me. Unless and until the company does not deliver the goods to me for transportation, I cannot give them a discount of 30%. I was the promiser, the company was the promisee. So my performance is dependent upon the performance of the promisee. Hence, the promisee will have to first perform, then only I will perform. Second example, practical life, whenever you go for taking a loan, the banker says, okay, we are ready to give you a loan provided you give us a collateral security. So now the promise of a banker to give a loan is depending upon your promise to give a collateral security. Till the time you don't give a collateral security, the banker won't give you a loan. So that is reciprocal promise, conditionally and dependently. Let us go on to the next part, that is point number 5, which talks about assignment and transfer. Assignment and succession, sorry. Point number 5, assignment and succession. First of all, what do you mean by assignment? The word assignment stands for transfer. The word assignment stands for transfer. In a similar way, the word succession also stands for transfer. Sir, Assignment also means transfer. Succession also means transfer. Are they both one and the same? I never said that. I said assignment is a transfer. Succession is also a transfer. But what's the difference between them? When I say assignment, it is a transfer done by parties to a contract. It is a transfer either done by the promisor or it is a transfer done by the promisee. But when I say succession, it is a transfer done by law. Any transfer done by law is called as a succession. Let us first focus upon assignment. So assignment is a transfer done by parties to a contract. And there are two parties to a contract. One is a promisor, another is a promisee. Promisor is a party of obligation. Whenever a promisor wants to transfer something, then that promisor will transfer his obligations. Whenever the promisor wants to transfer something, then that promisor will transfer his obligations. That is nothing but assignment of obligations. That is liabilities. Law says, sorry, that's not allowed in practical life. It's not practicable to transfer your obligations. For example, I made a promise to JK Shah sir that, sir, I promise to pay you 10 crore rupees which I had taken from you in past. So when I am promising to pay back that 10 crore rupees to JK Shah sir, can I say I am acting as the promisor and JK Shah sir is acting as the promisee? Yes, wherein I am the party of obligation and JK Shah sir is the party of rights. Now, I wanted to transfer my obligation to you all. I just said to you all, yes, all my dear friends, ladies and gentlemen, instead of me, who is having a willingness to pay 10 crore rupees to JK sir? Please raise your hands. I guess none of you will raise your hand because you are not interested to take my liabilities. That's a practical human approach. No one wants to pay liabilities on your behalf. So I tried to assign my obligations, but it was not possible, hence it is not allowed. Okay, even if I transfer my obligation, I said, oh, Karthik, on my behalf, you pay to JK sir. Karthik said, okay, sir, I will pay. Now Karthik failed to pay, then JK sir will catch hold of me or Karthik. Pretty obvious, JK sir will catch hold of me. So even after transferring my obligation, I was myself liable to JK Shah sir. Then what was the use of transferring the obligations? So practically, assignment of obligations not possible, hence it is not allowed. But if at all I say that I am a person having a right to recover 10 crores from JK Shah sir, so can I say over here I am a party of rights, I am a promisee? JK sir has made a promise that Kunal Shah sir, I promise to pay you 10 crore rupees. I promise to pay you 10 crore rupees. So JK Shah sir is the promiser. I am nothing but the promisee. I said, oh, I don't have time to go to JK Shah sir's place and recover 10 crore rupees. Hey, Karthik, can you please go on my behalf and take that money? Karthik said, yes, sir, obviously. I'm ready. I'm running right now, sir. You just wait. I'll be reaching to his place within a minute. See, when I was talking about transferring my obligation, no one was ready to take my obligations. But when I'm transferring my rights, people are dying to take my rights. So, assignment of rights is 100% allowed. It is 100% possible also. So assignment of obligation, practically not allowed. Assignment of rights, allowed. Let us go on to succession. Succession is nothing but a transfer done by law. When will law come into picture? Law will come into picture only when there is a death or insolvency of a party. See, one fine day, Kunal Shah died. The moment I died, there was my balance sheet. This is my asset side and this is my liability side. On the asset side, I was having an asset of 5,000 crores. And on the liability side, I was having a liability of only 500 crores. I have died. The moment I die, can I say all these assets will be transferred to my legal representative? Yes. So if my legal representative is taking away rights from me, then that legal representative will also have to take obligations from me. So that 500 crores ka obligation will also get transferred to my legal representative. So succession of rights allowed, succession of obligations is also allowed. But what is the maximum liability I can transfer to my legal representative? The maximum liability I can transfer to my legal representative is the maximum assets I had transferred to him. So my legal representative can be held liable only for the amount of assets he has inherited from me. Only for those assets he has inherited for me. Only for that much amount he will be held responsible. For other things he won't be held responsible. So under succession you can transfer your rights and you can as well as transfer your obligations as well. Let us go on to the last topic under Roman number 4, which talks about appropriation of payments. Another words for the same is application for the payments, or you can also see it as Clayton's rule. Yes, it was Mr. Clayton who has made this rule of appropriation. Law says that whenever there is a debtor who has taken multiple debts from a single creditor, whenever there is a debtor who has taken multiple debts from a single creditor, then in that case, whenever there is a point of repayment, then it is the debtor who will decide out of so many loans taken which loans he has repaid. However, if the debtor fails to apply, then such right is been given to the creditor to apply. The creditor can decide that which all loans he has considered that he has received back. However, if debtor fails, creditor also fails, then such right is given to the law, and law always and always appropriates them in an ascending order, irrespective whether it is a time barred debt or not. Once again, the rule of appropriation of payment says that whenever there is a debtor who has taken multiple loans from a single creditor, then at the time of repayment of those debts, it is the debtor who will decide that out of so many loans, which amount he has repaid. If the debtor says that I have repaid this, this, and this amount, then the creditor should give effect to only those amounts that he has received back. If the debtor fails to if the debtor fails to appropriate the payment, then the creditor can apply for the payments. Creditor thought that okay, this and this amount have received, then those amounts are been ticked that it has been received. However, if the debtor failed to appropriate, creditor also failed to appropriate, then in that case, appropriation will be done by law, and law will always and always appropriate them in an ascending order. Let us understand this entire thing with the help of an example. There's a person over here called as Mr. A who has taken some loans from a person called as Mr. B. The very first loan was taken in the year of January 2012. The amount of loan was rupees 50,000, wherein Mr. A made a promise that he is going to repay this 50,000 within a year, that is by 2013. However, in the year of 2013, Mr. A could not repay the amount and he had taken another loan in the same month of January 2013 of rupees 50,000. Wherein for that loan, he made a promise that he will repay that loan by 2014. But he did not repay the loan by 2014. In fact, he has taken a new loan in 2014 of rupees 1 lakh. So in that way, year after year, year after year, Mr. A has taken loan from Mr. B. And in every loan, he has made a promise to repay the loan by next year. But till now, none of the loans are being repaid. So the loan taken in 2012 was scheduled to be repaid in 2013. However, it is still unpaid till 2020. The loan taken in 2013 was scheduled to be repaid in 2014, but however, till until 2020, it is still unpaid. Total amount of loan taken 6 lakhs rupees. Now, on now on 1st October 2020, the debtor fails to repay some loan. So debtor fails to repay 2 lakh rupees back to the creditor. So debtor is going to the house of creditor and repaying 2 lakhs rupees. Law says, a debtor, it is your right. It is your right to apply which 2 lakhs rupees you are repaying. Debtor said, I'm repaying a loan of 2018, 19 and 20. So the creditor will have to give an effect only to those loans, that is 18, 19 and 20. See, the loans of 2012 to 2016, these entire loans are nothing but time bar debts. They are time bar debts. They are declared as debt by law. See, the amount of loan taken in 2016 was to be repaid in 17. The debtor failed to repay. The creditor was an aggrieved party. He could have filed a case against the debtor within 3 years, that is by January 2020. But January 2020 is already lapsed. It is October 2020 going on. So from loans taken from 2012 to 2016 are nothing but time barred debts. So debtor said, okay, I'm repaying you a loan taken for 18, 19 and 20. So creditor will have to give an effect only to those loans. But if at all, on 1st January, debtor just handed over 2 lakhs rupees into the hands of creditor, but he did not apply. Then in that case, application will be done by the creditor. Creditor can apply anywhere he wants to apply. Creditor thought, okay, I have received the repayment of 2014 and 2015. Then it is a repayment of 2014 and 2015. So first, the application ka right is given to the debtor. If the debtor fails to apply, then it is a right given to the creditor. Creditor can apply anywhere he wants to apply, irrespective whether it is time barred debt or not. However, debtor failed to apply, creditor also failed to apply. Debtor gave 2 lakhs rupees to creditor. Creditor have accepted the 2 lakhs and he has just kept inside his cupboard. None of the party have decided that which loans are being repaid. Then the repayment is done by law. It has been done by law. The repayment is done by law. Then in the eyes of law, the repayment is been done under a ascending order. So in the eyes of law, loans taken for 12, 13 and 14 are being repaid, irrespective whether time bar debt or not. So one last time, appropriation of payments. Whenever there is a debtor who has taken multiple debts from a single creditor, then at the time of repayment, it is the debtor who shall apply which amount of loans he has repaid. If the debtor fails to apply, then such application will be done by the creditor. Creditor can apply wherever he wants to apply for the payments. However, if both the parties fails to apply, then appropriation is done by law and law appropriates them in an ascending order, irrespective whether it is time barred debt or not. So friends, with this, we have completed our Roman number 4, which talked about something called as how to perform a contract. Now friends, let us go on to the last part. That is Roman number 5, which talks about how to discharge a contract. Whenever I talk about discharge of a contract, does that mean it's a beginning of a contract? No, it's not a beginning of a contract. It is actually the end of the contract. It is actually the end of the contract. Over here, discharge of a contract means end of a contract. It also means end of relationship between promisor and a promisee. It is an end of relationship between a promisor and a promisee. So whenever a contract gets discharged, the contract has come to an end. That is nothing but the contractual relationship between a promisor and promisee has also come to an end. In short, it is nothing but death of a contract. It is nothing but a death of a contract. Over here, there are various modes by which a contract can be discharged. See, there are 6 modes, there are 6 ways, there are 6 mediums by which a contract can be discharged. A contract can be discharged by performance. A contract can be discharged by mutual agreement. A contract can also get discharged by operation of law. A contract can also get discharged by lapse of time. A contract can also get discharged by impossibility of performance. Or else the last way is contract getting discharged by breach of contract. So friends, there are 6 ways by which a contract can be discharged. Let us discuss them. The very first one is a contract getting discharged by performance. Whenever I say that a contract is getting discharged by performance, then under performance, it can either be an actual performance or it can be an attempted performance, which we had done rightly just few hours back, just an hour back rather. Actual performance means both the parties are ready to perform, and both the parties who are ready to perform, they have actually performed it. The contract comes to an end because the contract is now executed in nature. I was ready to give the car, Karthik was ready to give me 10 lakhs. Both the parties are ready to perform. The moment we give our performances, the contract becomes executed. So through actual performance, the contract comes to an end. But there is also one more performance called as attempted performance. In attempted performance, promisor was ready to perform, but promisee was not ready to perform. Which means promisee was trying to do a breach of contract. Promisee was trying to do a breach of contract. So under attempted performance, the contract is actually not getting performed, but then also the contract gets discharges because it gets converted into breach of contract. And breach of contract is one of the way by which a contract gets discharged. So the very first way by which a contract gets discharged is discharged by performance, wherein it can either be an actual performance or it can also be an attempted performance. The second way by which a contract gets discharged is a discharge by mutual agreement. Discharge by mutual agreement. See, a contract gets formed through mutual agreement. Then in a similar way, the contract can also get discharged through mutual agreement. If I and you, we both can come together and form a contract, then yes, we both can also come together and discharge the contract. If promisor and promisee comes together to form a contract, then yes, that promisor and that promisee can also come together and discharge the contract. Wherein through a mutual agreement, you can either go for a novation, or you can go for rescission, or you can go for alterations, or you go for remissions. Whether you go for novations, rescissions, alterations, or remissions, whatever you want to do, you do it, but it has to be done through a mutual agreement. Under novation, a new contract gets formed. For that reason, the old contract gets discharged. The contracting parties who had already entered into a contract, now those parties are again entering into a new contract. For that reason, the old contract gets discharged. But when you are entering into a new contract, that has to be done through a mutual agreement, and through mutual agreement, you are discharging the old one as well. So novation means a new contract gets formed. Rescission means cancellation. I and JK sir entered into a contract, wherein as per the contract, I was going to travel to a place called as Ahmedabad in order to take lectures from 10th April to 20th April. The contract got entered on 1st April. I repeat, the contract got entered on 1st April and the contract was scheduled to be performed from 10th April to 20th April. But on 5th April, I went to JK Shah sir and I said to him, sir, I can't go to Ahmedabad. I've got some personal problems. I can't go to Ahmedabad. I have got some personal problems. See, I'm trying to do a breach of contract. JK sir could have easily filed a case against me for breach of contract. JK sir said, okay, no issues, beta. Let us do one thing. We both came together and we formed a contract. We both come together and cancel this contract. Through cancellation, the contract will be no more. So rescission means canceling the contract, which has to be done by mutual agreements, that is by both the parties. Alteration means to have changes inside the contract. Whenever you do any kind of changes inside the contract, yes, the contract gets discharged. For example, I was liable to pay 10 crore rupees to JK Shah sir. The contract was entered on 1st January and the contract was scheduled to be performed on 15th March. So on 15th March, it is my obligation to pay 10 crores to JK Shah sir. But before the due date of performance, on 10th March, I went to JK Shah sir's place and I said to him, sir, I doubt that I cannot perform the contract on 15th March. Sir said, wait, are you ready to pay me 10 crores? I said, I'm ready to pay 10 crores, but I'm doubtful to perform it on 15th March. Sir said, okay, when can you perform? I said, sir, I can perform on 19th March. Sir said, okay, perform the contract on 19th March. So see, we had done a changes inside the contract. The performance which was been scheduled on 15 March is now going to get performed on 19 March. Such alterations was not done by me alone. It was not done by JK Shah sir himself alone. It was done by mutual agreement. Not by me, not by him. It was done by us. Last topic, that is about remission, means to waive off, to settle up the some things. See, I was having a liability to pay 10 crores to JK Shah sir, which means JK Shah sir is having a right to recover 10 crore rupees from me. The due date of performance was now on 19th March. Now, before the due date, I went to JK Shah sir and I said to him, sir, I can't pay you 10 crores. JK sir got shocked. He said, you can't pay me. You can't pay me 10 crores. I can sue you. I said, wait, sir. I'm ready to pay you 9 crores, 99 lakhs, 99,900 rupees. I can't pay you entire 10 crores. JK sir is now thinking that, see, I'm having a right to recover entire 10 crores, but Kunal Shah is not paying me 100 rupees, which means I'm going to receive 9 crore 99 lakhs 99,900 rupees. Let me do one thing. Let me waive off this 100 rupees. It's better to have a loss of 100 rupees rather than to have a loss of entire 10 crores. JK sir said, okay, pay me whatever amount you want to pay me right now. That is 9 crore, 99 lakhs, 99,900 rupees. So this was a settlement done between me and JK sir. It was not done by me. It was not done by him. It was done by mutual agreement. So the second way by which a contract gets discharged is by mutual agreement, wherein it can be a situation towards novation or rescission or alteration or remission. The third way by which a contract gets discharged is by operation of law. Whenever I say operation of law, it simply stands for provisions of law. Operation of law simply stands for provisions of law. Whenever there is a death of a party, or whenever there is something called as insolvency, or whenever there is something called as unauthorized alterations, if any one of these things arises, then in that case, it is a contract getting discharged by operation of law. The contracting party died and it was involving personal skill and personal taste. Sorry to say, you cannot ask the legal representative to perform the contract. There was a contract between me and the painter. The painter gave a promise that he's going to paint a picture for me. Painting a picture involves personal skills. But before the painting gets completed, the painter died. I cannot ask the legal representative of the painter to paint a picture on his behalf. The contract has come to an end under operation of law, that is provision of law. Whenever after the contract gets entered and a contracting party becomes insolvent are persons who are disqualified by law. Sorry, the contract has become void. In that case, the contract gets discharged. Unauthorized alterations. You have done an alteration which is unauthorized one, then in that case also, the contract comes to an end under operation of law. It is nothing but a kind of a fraud done by you. You were not authorized to do that alterations, but then also you did it. It is an unauthorized alterations. The contract comes to an end. I gave you a check of 1 lakh, but you just added a zero in that check, which means the check is having a value of 10 lakhs now. You did some kind of fraud. So whatever was the unauthorized alterations done by you, sorry, under operation of law, the contract gets discharged. The fourth way by which a contract gets discharged is by lapse of time. Time expires, contract comes to an end. The best example over here is nothing but time bar debts, which has already been explained. The fifth way by which a contract gets discharged. A contract can also get discharged by impossibility of performance, wherein it can either be an initial impossibility or supervening impossibility. What is initial impossibility? The time when contract was formed, right from that time, it was impossible to perform. Initial impossibility means it was impossible to perform the contract right from the beginning. I will pay you 10 crores if you intersect two parallel lines. You said okay. But this contract is impossible to perform right from the beginning. So it is a contract getting discharged due to initial impossibility of performance. Rather, it is void ab initio over here. When I say supervening impossibility, the impossibility has arisen after the contract got formed. The impossibility has arisen after the contract got formed. So when the contract was entered, at that time, it was possible to perform. But before the performance, it is impossible to perform. It is a supervening impossibility, also called as doctrine of frustration. I and Shoaib Akhtar of Pakistan entered into a contract. When we entered into a contract, at that time, there was no war going on between India and Pakistan. But now, before the due date of performance, there was a war. And the war continued. The war continued. Now, is it possible to perform the contract which I entered with Shoaib Akhtar? No, it's an alien enemy now. So now, due to supervening impossibility, the contract has come to an end. So contract got discharged by supervening impossibility of performance. Initial impossibility means what? It is impossible right from the beginning. Before the contract got formed, it was impossible to perform. When I say supervening impossibility, it means it is an impossibility which arises after the contract got formed. When contract was entered, at that time it was possible to perform. But later on, before the performance, it has become impossible to perform. Last way by which a contract gets discharged, an important way, that is contract getting discharged by breach of contract. When I say breach of contract, which means one of the party has refused to perform the contract. Either he has refused to perform, or else the party has arranged a situation in such a way that it is not possible to perform the contract. It is not possible to perform the contract because the situation has been arranged by that party. Then in any of the situation, it is a breach of contract. I made a promise to JK Shah sir that I will be taking lectures at JK Shah classes from morning 7 to 9. From morning 7 a.m. to night p.m. I will be giving my services only to JK Shah classes. But later on, I refused him. No, I'm not interested to give you services. It's a breach of contract. Okay, I'm not refusing him, but I started taking lectures at some different classes. Which means I've done a situation wherein it is impossible to perform this contract of JK Shah sir. In that case also, I've done a breach of contract. See, breach are of two types. It can either be an actual breach of contract or it can either be an anticipatory breach of contract. What do you mean by anticipatory breach of contract? Anticipatory breach is a breach done before the due date of performance. If before the due date of performance, one of the party refuses to perform the contract, before the due date of performance, one of the party refuses to perform the contract, then it is nothing but anticipatory breach of contract. There was a contract between me and JK Shah sir, wherein Kunal Shah was going to conduct lectures at Ahmedabad branch from 10th April to 20th April. That is the due date of performance, 10th April to 20th April. The contract was entered on 1st April. So date of contract, 1st April. Due date of performance, 10th April to 20th April. Now, on 5th April, I went to JK Shah sir and I said to him, I am not interested to travel to a place called as Ahmedabad. Sorry, bye, take care. Can I say I'm refusing to perform? And such refusal was been given before the due date, which means I have done an anticipatory breach of contract. Now, if I have done an anticipatory breach of contract, can I say JK Shah sir is the aggrieved party? Yes, he has got two options. Either he can continue this contract up to the due date. JK Shah sir, option number one. On 5th April, Kunal Shah have done a breach of contract. Then option number one, JK Shah sir is having over here. keep the contract alive till 10th of April. If on 10th April Kunal Shah does not travel to Ahmedabad, then file a case against Kunal Shah. This is option number one. Or else option number two, file a case immediately. File a case immediately. In practical life, it's better to go for option number two, that is filing a case immediately. If you wait for option number one, there's a chance of supervening impossibility happen and the contract becomes void, wherein you won't have a chance to file a case later on. So better to go for option number two, that is file a case immediately. However, what do you mean by actual breach of contract? What is an actual breach of contract? It is the breach done on the due date or during performance. See, I was been asked to conduct lectures at Ahmedabad branch from 10th April to 20th April. On 10th April, I went to Ahmedabad, and from Ahmedabad airport, I made a call to JK Shah, sir. Not comfortable at Ahmedabad. I am coming back to Mumbai. Welcome me back to Mumbai. Bye bye. And I just disconnected the call. I caught a flight from Mumbai and I rushed back to Mumbai. Can I say I've done a breach of contract on due date? It's an actual breach. Okay. I had promised to conduct lectures at Ahmedabad from 10th to 20th April. I took the lecture on 10th, I took the lecture on 11th, I also took the lecture on 12th. Later on, I came back to Mumbai on 13th April. Can I say I've done a breach? And that breach is also called as an actual breach. So actual breach involves two things. Either the breach is done on due date or during performance, it is an actual breach of contract. Whenever there is a breach of contract, then the aggrieved party over here has got certain remedies. The aggrieved party over here have got certain remedies. What are the remedies available to an aggrieved party? The remedies available to an aggrieved party: number one, JK sir is an aggrieved party. He can file a case against me. Second, JK sir also has a right to claim damages from me. Because of my breach, if JK sir is going to suffer from any kind of losses, then yes, JK sir is having a right to claim damages from me. Damages are of various types. Ordinary damages, which means JK sir will recover only and only the ordinary course of losses which he is going to suffer from. However, if JK sir has already communicated me some special circumstances, and then also I'm doing a breach, then JK sir is also having a right to demand special damages. Special damages can be demanded only when special circumstances were being communicated, as it was held in the case of Headley versus Bexandel. Yes, there is a damage called as exemplary damages, vindictive damages, or punitive damages. They are not monetary in nature. These damages are not monetary in nature. The aggrieved party over here wants to punish the defaulting party. Send the defaulting party to an imprisonment. That's punitive, punishment, punitive damages. Nominal damages means the aggrieved party has not suffered any kind of loss, but only for name's sake, he has got a right to demand damages, so he's demanding damages. The amount of damages can be 1 rupee, 2 rupee, 5 rupee, 10 rupee. So they're actually not damages, they're just for namesake damages. Remote damages. Law says aggrieved party cannot demand remote damages. You cannot demand damages which are remotely located. If I'm standing at a roadside and I'm met with an accident, then in that case, I can claim medical expenses from the driver of the car. But I cannot demand from him that I was waiting over here for my friend. He was going to take me for an interview. Now I won't be able to go for an interview. I will be unemployed. Please pay me unemployment ka charges. If I'm unemployed, my father will throw me out of the house. Please pay me the money also for buying a new house. My girlfriend will leave me. Please pay me compensation for that also. And what nonsense. You're asking for damages which are remotely located. Not allowed. Remote damages are not damages. Next, deterioration for delay. Whenever there is a fixed time under which a delivery of goods has to be done, and however, the delivery is not done during that time, there is some delay. And due to this delay, if the goods get spoiled, then the transport company will have to pay some damages that are called as deterioration for delay. Last, liquidated damages or penalties. Under Indian law, they both are same, but under English law, they have been bifurcated. What are penalties? Inside the contract, an amount has been written that if any person does a breach, then that person will have to pay X amount to default to another person. Inside the contract between me and JK sir, it was rightly been written that if at all I do a breach of contract, then I will be liable to pay 5 lakhs rupees to JK sir, and vice versa also. So if later on in future JK Shah sir does a breach of contract, he will have to pay 5 lakhs rupees to me. If I do a breach of contract, then I will have to pay 5 lakhs rupees to JK Shah sir. That is the amount which is already been mentioned inside the contract is called as a penalty. It is a predetermined amount which is been justified one. Next right, suit for specific performance. Yes, aggrieved party also has a right to demand specific performance. Aggrieved party will go to the court. An aggrieved party will ask the court to pass an order that please ask the defaulting party to perform the contract as it was specified inside the contract. I made a contract with Karthik that I'm going to sell him an antique car. Antique car. Later on, I said, no, I'm not interested to sell you the car. Then in that case, Karthik can go to the court and ask for specific performance. Yes, the court can give me an order. Kindly sell that antique car to Karthik. Specific performance can be performed only when the court orders. If the court does not orders, then in that case, I don't need to perform specifically. One more right, suit for injunction, that is a stay order. In that case, the aggrieved party will go to the court and ask the court that please tell the defaulting party not to do an activity which the defaulting party had already said that he will not do it. I made a promise to JK Shah sir that I'm going to conduct lectures only at his own classes and nowhere else, which means I'm not going to conduct lectures for other classes. After 5-6 days, I started conducting lectures at other classes also. So JK sir, being an aggrieved party, can go to the court and ask for injunction. When the court can order me, kindly don't do an activity which you had promised that you are not going to do it. So whether you talk about specific performance or whether you talk about injunction, they are possible only when the court orders, otherwise not. Last, suit for quantum merit. Quantum merit stands for as much as earned. Doctrine of restitution is one of the point towards quantum merit itself. Over here, for example, there was a movie producer and there was an actor. There was a contract between them. As per the contract, the actor is going to provide services to the producer and the producer is going to provide 100 crore rupees of funds to the actor. Now, the production of the film got started. Approximately 20% of the film was being produced, and later on, the government of the country gave an order that you should not produce films in this country, which means now it is void, impossible to perform. So law says actor has already given a services of 20%, then yes, the movie producer has to pay 20% of the amount to the actor as promised. That is as much as earned, that is quantum merit. Last topic over here, that is contingent contract. Contingent contract. It is a contract to do or not to do something. If some event collateral to a contract does or does not happen. It's a miscellaneous topic. Contingent contract. It is a contract to do or not to do something if some event collateral to such contract does or does not happen. For example, I promise to pay you 10 crores. That's a contract, no? I promise to pay you 10 crores. That's a contract. If your house catches fire. So my promise to pay you 10 crores is depending upon an event called as house catching fire. If your house catches fire, I will pay you 10 crores. If your house does not catch fire, I won't pay you 10 crores. One more example. I will pay you 100 crores. That's a contract. I will pay you 100 crores. That's a promise from my side. And I will pay you 100 crores. If your ship does not returns. If your ship returns, I won't pay you 100 crores. But if your ship does not returns, I will pay you 100 crores. Generally, contingent contracts are always and always valid in nature. There is only one exceptional case, that is contingent contract to do impossible acts, wherein it is void. Otherwise, they are always and always valid in nature. There's a difference between contingent and wagering. There's a difference between contingent and wagering. What's the difference? Wagering are void, contingent are valid. Under wagering, there are something called as betting transactions, but under contingent, there is nothing called as betting transactions. Under wagering, there is something called as a chance of winning or losing, but under contingent, there is no such chance of winning or losing. Under wagering, there may or may not be a reciprocal promise. Yes, if India wins, then I will have to pay you. Sorry, you will have to pay me. If Pakistan wins, I will pay you. So there may or may not be a reciprocal promises. So there's a difference between contingent and wagering over here. Are you sure? So, friends, with this, we have completed the entire provisions towards Indian Contract Act 1872 under a marathon revision lecture. In my next lecture, I will be continuing with a topic called as I will be starting a topic called as Partnership Act 1932. Till that time, see you. Have a great day. Study well. Bye bye.